Madam Clerk, can we have a roll call, please?
Councilmember Wilkinson,
Present.
Councilmember Cooper,
Present.
Mayor Mark,
Here.
Councilmember Lynch,
Here.
Councilmember Chemnitzer.
Here.
Thank you. Moving on to reports and presentations. Are there any reports by city council members tonight? Seeing none, thank you. Move on to the city manager's report.
Thank you, Mayor Mark, and good evening, City Council and members of the public in attendance this evening. I'll start by reminding everyone that our annual town meeting has been scheduled for February 13th at 6 p.m. We invite our community to attend this event and to hear a summary of the state of the city, and of course, join us in celebrating our 2023 Citizen of the Year and Citizen Emeritus awardees. The meeting will be held downstairs in the Belvedere Community Center. This is a fun event and we look forward to it. So please save the date and we hope you can all attend. If you've been driving around town over the past couple of weeks, you may have encountered the new stop sign in front of City Hall. For those who are not aware, this is a complex four-way intersection where streets merge at odd angles and elevations. It receives a high volume of daily traffic, including pickup and drop off of young children for school. The stop sign was installed to slow down drivers and improve intersection safety and visibility. We've heard comments from residents already that it's a long needed change. So thank you, Tony, and our public works team for having that installed. And of course, our city council for your commitment to safe streets. On the topic of scheduling, you may have noticed that due to the housing element adoption, our city council meeting schedule is different for the month of January. The city's newsletter typically follows the council meeting, so please look for that publication this Friday. Things will return to normal in February, and our next regular council meeting will be on February 12th. That's all I have for now.
Thank you very much. I also wanted to mention that I've been reminded to ask city council members to speak into the mic as there's a large audience on Zoom this evening. With that, Police Chief, can we have your report, please?
Get this queue up. That's all right. Apologize for the okay, there we go. Good evening, Mayor Mark, council members. Tonight, I am pleased to present the police department's fourth quarter report for 2023. I always like to start off by stating that the hallmark of the police department is our unparalleled personalized service that allows our residents to enjoy a very unique quality of life. Starting off with the RIPA data, 6 individuals were detained based on 3 calls for services and 3 officer-initiated contacts during this last quarter. Of the 6 stops, 3 were for vehicle code violations, 1 was for suspicious criminal activity, 1 was for a suspicious vehicle, and 1 was for domestic violence. In all, 3 warnings were provided with 2 no actions taken and 1 arrest made. The perceived racial compositions consist of 1 Hispanic, 1 Asian or Middle Eastern, and 4 Caucasians. During this quarter, the police department handled 592 incidents, which included 2 Part 1 offenses, highlighted in bold there, and 5 Part 2 offenses, which are also highlighted in bold. The remaining 585 incidents are classified as all other incidents. Most incidents handled this quarter were in response to calls for service from our residents. During this quarter, the department conducted 6 traffic stops, made 1 arrest with referral for prosecution, received several citizens' appreciations, and hired a new police officer. 58 coyote-related incidents were also reported during this quarter. As part of our ongoing professional development, PD personnel attended online and in-person training that were either mandated or for knowledge and skill enhancements. We also updated 24 lexical policies in accordance with the minute laws, and they are detailed in the staff report. Lastly, the PD continues to be active in community events, which we always take great pride and joy in being part of. And this includes my report, and staff is available for questions.
Thank you so much. Do we have any questions for Chief Wu? Just one real quick question. The 58 coyote reports, how does that track versus a year ago at this time? Do you have that information?
It tracks approximately the same. There was an uptick from the last quarter, and in consultation with our wildlife expert, the takeaway is that there's no upticks in the number of coyotes. What the upticks is attributed to, in her opinion, to seasonal milestone activities, such as the dispersal of young coyotes from Tiburon into Belvedere. And secondly, people are more used to using the reporting forms, as well as officers being even more proactive than before. And sometimes when one single howling can account for multiple reports. And so, but the takeaway is that there's no uptick in number of coyotes in Belvedere.
Thank you for that report. As a further scheduling adjustments, we're going to hear the other schedule item 6A and 6B following the consent calendar, so we can move a little more efficiently through the evening. So with that, can I ask to move to the consent calendar? And is there any questions from the council, items on the consent calendar? I'm sorry.
Excuse me, Mayor Mark, I think you may want to provide a brief opportunity for public comment on the police department's report.
I apologize. Open the public comment for both the city council report and the police report.
And perhaps just the city manager report, just in case.
I just said that. Is that the city council?
You said city council.
I apologize. City council, city manager, and police chief report.
No problem. Thank you.
Seeing none in the room here, Madam Clerk, anybody online?
Mayor Mark, there are no hands raised.
Thank you. I apologize for that omission. So the consent calendar, once again, any comments from city council members or questions?
I have a comment. I don't wish to pull an item, and I don't think it's required. But as I was absent last week during the first reading and discussion of 4E, I wish to have the minutes reflect that I will be abstaining since I was absent from the first reading. And I'll still vote on the remaining items on the consent calendar. So my vote will just exclude
Thank you.
4E.
Thank you. Are there any comments from the public relating to the consent calendar or to pull an item? Seeing none, Madam Clerk, anybody online with a comment about this consent calendar?
I see none.
Is there a public comment period on the consent calendar, or is it sufficient to ask for the comments for it?
I think you've already taken public comment on the consent calendar, Mayor.
Okay.
I think in clarifying procedure, I think we should just call for a vote on 4A through 4D and then separately a vote on 4E.
Okay.
Thank you.
May I have a motion for consent calendar items 4A through 4D?
I so move.
Second.
All in favor?
Aye.
Aye.
Any opposed? None. Can we please have a motion for item 4E?
So moved.
Second.
All in favor?
Aye.
Aye.
Abstain.
Thank you. Moving on now to other schedule items. Item 6A. I believe city manager will have a report on this. No, yes, you will. Or do I jump into that?
You can go ahead and take that one. I think it's pretty straightforward.
So the item 6A is a discussion of the council committee assignments. And I would like to recommend that a few alternate and a few backup positions that I replace Councilmember Jim Lynch on the Marine Clean Energy alternate position behind Councilmember Wilkinson, that Councilmember Cooper replace me behind Councilmember Kimnitzer on the Disaster Preparedness Committee, and that I fill the vacant alternate position behind Councilmember Kimnitzer in the Legislative Committee of MCCMC. Any further comments or thoughts on that?
Not specifically on those changes, but I want to note also, and it probably should be mentioned, I am the alternate for the MCCMC assembly on the executive committee of ABAG, the Association of Bay Area Governments. And I also attend the annual General Assembly on behalf of Belvedere. I believe that's in the fall. It's mentioned spring in
Okay.
here, so you might just delete that. Maybe it changes from year to year, but last year it was in the fall.
And I'll just add one item. I serve on the League of California's Revenue and Taxation Committee, which isn't listed there, and that meets 4 times a year.
Did you catch those notes, or should I repeat them?
No, we've got them. Thank you.
Okay, so could I have a motion to approve the committee assignments for 2024?
I
So
so
moved.
moved. Oh, second.
All in favor?
Just a quick point. I think we
Sure.
do need public comment on the one. I'm sorry.
You're right, I apologize. Public comment on the city council committee assignments. Seeing none, Madam Clerk,
Mayor Mark, I see none.
may I have a motion, please?
So moved.
Second.
All in favor?
Aye.
Aye.
Thank you. Moving on to item 6B. I believe, Robert, you have a comment, a report for that.
Sure, I can introduce this item. Thank you, Mayor and Council. The State Route 131 Capital Preventative Maintenance Project is a new project proposed by Caltrans. Their team is currently wrapping up their environmental review, and it's estimated that work will begin in the summer of 2025 with a total project duration of about 12 to 18 months. The scope of work covers a 4.6-mile stretch of East Blythedale Avenue in Mill Valley and Tiburon Boulevard, addressing pavement issues like rutting, potholing, and cracking. Additionally, the plan includes upgrades to intersections, curb ramps, guardrails, drainage, and electrical systems. The project also proposes the addition of various classes of bikeways, class 1, 2, 3, and 4, to improve the active transportation network. Your staff report provides a definition of those different classifications and a graphic as an attachment A for reference. As I said, Caltrans is conducting its environmental analysis for the project and will accept comments from Belvedere for the record and for consideration. The attached draft letter addresses some of the obvious areas that staff would like to see clarified or addressed by Caltrans before they complete their engineering and final design work. And I'll summarize those. First, we're recommending that Belvedere has a seat at the table when reviewing and approving their traffic management plan. Also, prior to and during construction, we are recommending that Caltrans create a resident outreach portal for project updates and news. Also, we're recommending that Caltrans conduct a detailed traffic study to evaluate the need and impact of new bike lanes and crosswalks, specifically in the area of Tiburon Boulevard between the Cove Shopping Center and Blackie's Pasture, where an established bike route already exists. And then finally, we are requesting a cost analysis for the implementation of the new bike lanes. Again, the City Council is encouraged to consider these points. We recommend you approve the attached letter as it's written or with any possible changes you request this evening. That concludes my report. I'm happy to take questions if there are any.
Thank you. Do any council members have questions to the city manager? Seeing none, before we bring it back for comments, open the public comment on this item. Seeing none in the room, any on Zoom or downstairs?
We have David Sandrich.
Please go ahead, David.
Yeah, hi. Question is, and I didn't hear if the city manager mentioned it, is there any request to Caltrans to evaluate impact or change of impact in traffic patterns due to either the Tiburon or Belvedere proposed housing elements?
specifically in this project, no, they're not addressing those.
But if we're asking for impact on other things, wouldn't now be the time to just ask them to do the general study?
I would imagine that our city and their town's respective environmental reviews would have studied and identified those traffic impacts. I don't know.
Yeah, I know the class 2, class 3, class 4 bike lanes that are being proposed for the project are part of the Tiburon general plan. One of their elements just for traffic management. That's something they've studied. It's outlined as one of the areas that they'd like to see improved. So it is consistent with Tiburon's plan for that area. I'm not sure if that addresses your question or not.
Well, if it does, if it accounts for the imminent planning of increased density in either Tiburon or Belvedere, and this is Belvedere, then that's okay. But from your description, it did not sound like it accounts for that. And I would say if we're doing a study about the change of this major thoroughfare because of the bike lane, it should also incorporate, you know, a what if, or not even a what if. Here's the proposed housing element, and here's how we expect that to be impacted.
Thank you. Robert,
Anyways,
would
that's my
think-
comment.
Yeah, thank you. I would think
Yep.
item A in the letter, item 1 in your staff report, could including the increased density associated with the current cycle housing elements for each respective municipality, something along those lines. Thank you. Any additional public comment?
I see none.
Thank you. Bring it back to close public comment and bring it back to City Council for comment.
Sure, I'll go first. I mean, I think it's a useful step that we're doing this. I do think, as we all know, Tiburon Boulevard is already at a log jam during certain times of day, and to add bike lanes, which may slow traffic out of Trestle Glen, as well as remove the pullovers on the side, to me is potentially really problematic. And so I think it's really important that we ask Caltrans to do a really thorough evaluation of cost benefit in terms of adding bike lanes where a very safe road already exists on Greenwood Cove Road, all the way from the 76 through to Blackies. So I think it's important we do this, and I would certainly encourage members of the public to also write into Caltrans, because final design is still quite a long way away. So Robert, I was wondering whether you know if members of the public want to also write in with concerns or questions where they should email or call.
Yeah, I can provide that information if they want to reach out to the city. Caltrans
Can we
does
put it
have
on
an
the city's
information.
Can we put it on the city's website?
We do, and Caltrans does have an information portal on their website as
Okay,
well.
thank you.
Access it.
Yes, I have some comments as well. In the newsletter that follows this meeting, I think it would be very good to provide the public that website for public engagement. I think this is a very important time to be doing that. I also think that the comments from Mr. Sandwich that we just heard are valid. It's possible that the overall capacity that traffic specialists refer to may not be within the scope of this, but still, it's important for us to tee up those concerns early in the process. And then if further Caltrans proposals come forward that would be increasing the capacity of that critical ingress and egress, we would be on record as having raised them every single time this comes up. I was also somewhat concerned about attachment A, which is the proposed site plan for the new bike lanes. I think it's very important to improve the safety for cyclists along that stretch. And I think it's really good that we're beginning this conversation, but I hope it doesn't end here, because sometimes I see cyclists trying to find their way up Tiburon Boulevard between Trestle Glen and Stewart. That's a very, very dangerous place. Obviously, those cyclists are lost because they have not reached the existing bike path. And I've spoken with a number of cyclists, not the full group of cyclists we have here, but the Greenwood Beach bypass, let's call it, is actually a perfectly good path for cyclists between Blackfield Road, so Cove Shopping Center, and where the designated off-street bike path begins at Blackie's Pasture. Secondly, we have a lot of tourists on their rented bikes coming into Tiburon and Belvedere. And it's really easy for them to get lost, and it's a traffic hazard. So I think that the idea of adding this on-street designated bike path shown on attachment A actually makes it less safe. So I think you've raised it in the letter. I would like to see that point maybe enhanced and emphasized for the safety not only of cyclists coming in, but for the cars that are using Tiburon Boulevard every day. So thank you very much for eyes on this issue. I think it's really important to hear from the cyclists in our community, and offering that that website will give that opportunity to our residents.
Thank you.
Yeah, I would just add, I think this letter is excellent. I'm glad it's written. I think we should submit it. I'd propose that we add a bullet point under C, where we're asking for a focused traffic study to ask about the utility and effectiveness of the Class 1 lane that is proposed to go from Greenwood Beach to East Strawberry. My understanding is that's a two-way lane divided by a hard barrier. And there's already going to be a westbound Class 4 lane on the north side of that street. So we'd have 3 bike lanes there, and that would require changing the median in that stretch of Tiburon Boulevard and a few other things. So I think we should just ask them to tease that out on the traffic study as well.
I'm not sure how many of you ride your bikes along there. I actually do. I ride to the Cove Shopping Center. So that's the exact route that we're talking about. And I think, I don't know if it's an issue, but when you're coming back from the Cove to get to the bike path, there's a funny little curve in there that's hard to see. And I'm curious if Tiburon has looked at that, because I wonder if that's an area that cyclists are opposed to. Because if you're with a big group, you'd have to almost come to a stop to be able to maneuver through this very narrow, it's sort of an S that it throws you through. So if they would look at that, I think Nancy's right. It's much safer to be on Greenwood Road where there's almost no cars at all because it's a dead end. And so if they can look at opening up for the cyclists, it might take away any pressure for adding lanes.
Thank you. I agree with the comments, and I think we could make a few modest additions to the letter. I think their intent in the attachment that was referenced is to keep outward traffic on the outward side and inbound traffic on the inbound side. But as Councilmember Kimitzer pointed out, there's a required crossing or merging into the Blackie Pasture Road at some point. Why do it at a point at Trestle Glen, which seems to be the least safe place to do it, and offers the most potential confusion for people unfamiliar with the traffic patterns. So I don't know whether because we've resisted making specific design comments. Should we? Do you think we should make specific design comments, or say that we do have design comments, a number of design comments, and ask for the time and place to be consulted on those matters?
Yeah, I think the latter of those two is a better option.
Okay, Thank you.
Councilmember Mark, Mayor Mark, if I may just add, could, it occurs to me that we are suggesting they at least consider a route that is not Caltrans. So I am our commissioner to the Transportation Authority of Marin. And there's often a question of whose jurisdiction is this? Usually we think of who is paying for it, but there is the front end of that is who is designing it. And I think it might be very helpful for you to copy the Executive Director, Ann Richmond of the Transportation Authority of Marin.
Sure, I can do that. Thank you for the suggestion.
There's a time constraint for the submittal, I believe, correct?
There is the 25th.
So can we approve, do you have the proper comments to approve or approve it with the comments and the conditions, not the conditions, but the comments that we've added to the letter?
I do, yeah. I have the record tonight of that, and I've made my own notes. You and I can certainly collaborate afterwards too to make sure we've captured all those.
Thank you. Can I entertain a motion to approve the submission of the letter to Caltrans as commented on and modified this evening?
So moved.
Second.
Thank you. All in favor?
Aye.
Aye.
All opposed? None? Thank you. Now moving to the public hearing portion, item 5A, discussion of possible action on the appeal for property located at 1 through 22 Mallard Point Road, or Mallard Road, I should say. As I turn this over,
Mayor Mark,
I apologize. Yes.
I have to announce that I am recused from this item because I own property within 500 feet of the project. And for those present, that means that I am required to leave the room for this item. So I will do so.
Thank you. Before I turn this over to our city staff for their comments on the appeal initially, I just wanted to introduce the appeal procedure. We will ask our city staff for a presentation on the appeal. We will then, at every opportunity when someone speaks, the city council will pause and ask questions should they have need for clarification or additional comment. Arguments in favor, the appeal will be presented not to exceed 15 minutes. Likewise, the city council can pause and ask questions to the appellant at that point in time. Arguments opposing the appeal for 15 minutes. Will then give the appellant the opportunity to comment on or rebut or have 5 minutes to comment at that point in time. We'll open the public hearing and we'll allow the public to speak for up to 3 minutes, an additional 3 minutes should someone cede their time. I would like to request that if your point has been made or if you feel you're supporting an existing point that's been mentioned, brevity would be greatly appreciated. I believe our brains will work better at 10:30 than they will at midnight or later. So I think as we move along would be greatly appreciated. Following that public hearing or as part of that public hearing, the appellant will once again have the opportunity to respond to the public comments, and then we'll bring the discussion back to council for formal action to approve, deny, or continue review of the appeal. With that, I will turn it over to our city staff to introduce the item, please.
Mayor Mark, with your leave, before we delve into the substance of this matter, I did want to briefly address correspondence that we received from Mr. Riley Hurd on behalf of the appellants, and I'm responding on behalf of Councilmember Cooper. Today, actually this afternoon, we received a letter from Mr. Hurd raising concerns about Councilmember Cooper's participation in tonight's hearing. And I just want to make it very clear for the record that she does not have any legal conflict, that is any legal conflict whatsoever that prevents her from participating tonight. Very briefly, Mr. Hurd makes two arguments in his letter. The first is that Councilmember Cooper has a financial conflict of interest due to the proximity of her home to the proposed project. But as his letter acknowledges, she lives outside of the 500-foot radius that creates a presumptive conflict of interest. She lives beyond that distance, thus there is no strong presumption of a conflict of interest. And I want to reassure the public, and of course, Mr. Hurd, that we did all the required legal analysis to determine that she had no financial bar on her participation tonight. Secondly, Mr. Hurd raises concerns about Councilmember Cooper's involvement in the Brig organization. I want to just say on behalf of Councilmember Cooper to clarify the record and clarify some of the factual claims in the letter that Councilmember Cooper was never a founder of Brig, has never been a board member of Brig, and since deciding to run for office in 2022, she is not affiliated with Brig whatsoever. So I just want to state that for the record. Thank you so much.
Good evening, Mayor Mark and council members. On November 14th, 2023, the Planning Commission considered a project located at 1 to 22 Mallard Road for design review, demolition, tentative map, subdivision, and revocable license. The project at 1 to 22 Mallard consists of 40 units and proposes 6 single-family homes, 5 duplexes, and 23 units in an apartment building. 4 of the units would be affordable to lower-income households. The request includes 1 concession and multiple waivers under state density bonus law. The Planning Commission heard from staff, the project sponsor, and their attorneys and consultants. The public hearing was opened, and there were numerous residents who spoke about the project. At the Planning Commission hearing, staff recommended approval of the project and that the Planning Commission find that the project is eligible for the Class 32 infill exemption. The staff recommendation for approval of the exemption was based primarily on an analysis of 13 reports submitted by the applicants and their consultants, an analysis of general plan and zoning consistency prepared by staff, and a peer review and analysis of those reports as prepared by Ascent Environmental. The reports included a biological site assessment, preliminary geotechnical investigation, stormwater control plan, drainage, construction noise impact study, and transportation study. On November 14th, 2023, the Planning Commission unanimously found that the project did not qualify for the Class 32 infill exemption. The remainder of the project approvals remain pending while this appeal proceeds. Pursuant to the Belvedere Municipal Code, any interested person or applicant may file an appeal with the City Council from any denial, approval, or condition of approval or any application by the Planning Commission. On November 27th, 2023, Mr. Bruce Dorfman, on behalf of Mallard Point, filed a timely appeal from the Planning Commission's decision. Thereafter, on December 19th, 2023, Riley Hurd, the project sponsor's legal representative, provided a further explanation of the appellant's arguments. For the purposes of this presentation, we will focus on whether the Belvedere Lagoon is an urban use, whether the adjacency of the Belvedere Lagoon constitutes an unusual circumstance and impacts on water quality. I will now turn this presentation over to Barbara Kautz, Special Counsel, who will go over the legal requirements for CEQA.
Thanks, Rebecca. So this part of the presentation talks about the standards for qualifying for the Class 32 exemption, which is often called the infill exemption. So to qualify for a Class 32 exemption, there has to be substantial evidence in the record to support 5 different findings. 1, that the project's consistent with the applicable general plan and zoning designations, that it's within city limits on a project site of no more than 5 acres, that is substantially surrounded by urban uses, that it has no value as habitat for endangered, rare, or threatened species, that the project approval would not result in any significant effects on traffic noise, air quality, or water quality, and that the site can be served by all required utilities and public services. And I highlighted in red on this slide the issues that arose at the Planning Commission hearing, whether the project was substantially surrounded by urban uses and whether there might be any significant effects on water quality. So next slide. There are also exceptions to the Class 32 exemptions even if the project satisfies those 5 requirements. One, that the cumulative impact of projects of the same type in the same place and over time is significant. Second, that there's a reasonable possibility that the activity will have a significant effect on the environment due to unusual circumstances, which was the issue, the requirement at issue at the Planning Commission hearing, that it could result in damage to scenic resources within a highway officially designated as a state scenic highway, that it's located on a site which is included on a list of hazardous waste sites that's prepared by the state, or that the project may cause a substantial adverse change in the significance of a historical resource. So at the hearing, next slide. So at the hearing, the Planning Commission primarily based its finding that the project was not eligible for the Class 32 exemption based on these 3 reasons. First, the commission found that the project is not substantially surrounded by urban uses. The Belvedere Lagoon comprises about over half the project property boundary, and the Planning Commission concluded that the Belvedere Lagoon is not an urban use. Secondly, the commission felt that the project approval may have significant impacts on water quality. They concluded that the analysis of the impacts on water quality did not adequately consider the failing bulkheads and potential soil erosion into the lagoon during construction. And lastly, with the unusual circumstances exemption, the commission concluded that there were unusual circumstances that were related primarily to the length of the site along the lagoon with the failing bulkheads, the location of the site within a flood zone and underlain by bay mud susceptible to liquefaction and settlement, and that these unusual circumstances might cause sedimentation into the lagoon and have a significant impact on water quality and the lagoon habitat. So here we're basically going to go through the legal standards and the evidence, a summary of the evidence, because it was pretty extensive and we can't discuss it all related to each of these issues. So the next slide. So regardless of what decision the city makes, it has to be supported by substantial evidence. The courts don't weigh conflicting evidence if the city's own evidence is substantial. But as a fact finder, the city may weigh conflicting evidence in reaching its conclusions. So you're a little bit different from the court. You can consider the evidence both for and against each of these issues and decide which you find more, which you wish to base your decision on. It's not a preponderance of the evidence standard. It's just whether there's substantial evidence to support what you do, which is quite different from how we normally think about court trials. It's a generous standard to the city. Substantial evidence is defined in CEQA as enough relevant information and reasonable inferences from the information that a fair argument can be made to support a conclusion, even though other conclusions may also be reached. So there can be substantial evidence both for and against a conclusion. Substantial evidence is facts, assumptions predicated on facts, and expert opinion supported by facts. At times, the courts have rejected lay opinion, but sometimes they accept it. It doesn't include argument, speculation, unsubstantiated opinion, or evidence that's erroneous or inaccurate. And a court said it has to be reasonable in nature, credible, and of solid value. But if the issue is the scope of what we call the scope of the exemption or a definition of what the terms mean, a court will undertake what they call de novo review, meaning they look at it themselves without any kind of deference to the city's findings. Next slide. The first issue is whether the Belvedere Lagoon is in urban use. There's really no disagreement about the facts. The Belvedere Lagoon comprises more than half of the boundary of the property, and the issue is whether the site is substantially surrounded by an urban use. So the lead case on this issue, a 2006 case out of San Diego, said that an urban use is characteristic of a city or a densely populated area, and that whether a use is urban or not refers more to the location and characteristics of the use than to the type of use. And there's an example that a home in the middle of farm country may be rural, but a home, say in Belvedere, is urban. The Public Resources Code, which is the code in which the California Environmental Quality Act is located, defines qualified urban uses and substantially surrounded, but the exemption, the infill exemption was adopted prior to adoption of either definition, and the court chose not to use the definition of qualified urban uses that had already been adopted when it decided the Bankers Hill case. Next slide. So what evidence has been cited for determining that the lagoon's in urban use? So in terms of determining that that in favor of supporting the definition, the determination that the site is surrounded by substantially surrounded by urban uses, is the fact that the lagoon's located in the middle of the city. It's surrounded by urban residential development. It's man-made and used for private recreation. It's dredged with algicides applied, and the applicant has pointed out in the appeal letter that various general plan policies describe it in ways, in similar ways. But the Planning Commission determined that in terms of evidence against its being an urban use is that it's a wetland and subject to jurisdiction of the Army Corps of Engineers and the Regional Water Board. It originated as arm of San Francisco Bay, even though it was, even though the present design of it was created man-made, that it doesn't meet the definition of qualified urban use. And unlike Balboa Park, which was considered in the Bankers Hill case, it's not landscaped and there's no urban amenities there. Next slide. So the next issue is whether there are potential impacts on water quality. And so the city has to find that the project would not result in any significant effects relating to water quality. And there has to be substantial evidence to support the finding or to conclude that the finding cannot be made. So the evidence supporting the recommendation, the original staff recommendation to find the project exempt is that extensive measures are routinely imposed both by the city and regulatory agencies during construction. The most important regulatory agencies are the Regional Water Quality Control Board and the Army Corps of Engineers. Also, adopted regulations require that the site use what are called BMPs or best management practices. Stormwater plans are required and so forth. A letter was submitted into the record or an email from the Regional Water Quality Control Board stating that it imposes the same standards whether or not the project receives an exemption. Also, that after completion, there's evidence that the project will reduce the amount of impervious surface on the site and improve the quality of stormwater because various filtration basins will be required. But the evidence against this was that the bulkheads are failing and demolition, grading, and construction may cause slumping into the lagoon. that the existing fill is unstable. And I think particularly a theme in many of the letters is that the existing analysis is not detailed enough to support the finding. And then the last issue are about unusual circumstances that may result in significant impacts. So the legal guidance in this comes from a 2015 case from the California Supreme Court called Berkeley Hillside Preservation versus the City of Berkeley. And there has to be substantial evidence in the record to make this finding that the project's unusual because it has a feature that distinguishes it from others eligible for the exemption, such as its size or location. If there's, contrarily, if there is substantial evidence that the project is not unusual, the courts will uphold the city's finding. Then only if the city finds that there's something unusual about the project, then it must also find there's a reasonable possibility of a significant effect due to the unusual circumstances. So unless the council decides that there's something unusual about the project, the issue of the impacts does not come into play. Next. And so the evidence supporting no unusual circumstances were that there is very similar construction adjacent to the lagoon involving sites in a floodplain and with similar soils conditions, and that this type of the construction next to the lagoon is common in Belvedere, and that bulkhead reconstruction is common and is commonly approved by the city, and the conditions are applied at the building permit stage. The Planning Commission found that the length of the area adjacent to the lagoon and the extent of the failing bulkheads was not usual, that the extensive demolition and site grading was unusual, and that the combination of features, the failing bulkheads, unstable soil, et cetera, is unusual. So, last slide. Oh, and then the impacts from the unusual circumstances. The impacts that's been cited again is that there has to be substantial evidence that there's a reasonable possibility of significant impacts due to unusual circumstances. And this is basically, again, revolves around potential water quality impacts. And these are the same as I went through before. Next slide. And so the council should review the appeal and determine whether the project qualifies for the Class 32 infill exemption. And in particular, the council should determine whether the project substantially surrounded by urban uses, whether it would impact water quality, and whether there are unusual circumstances applicable to the project that might result in the reasonable possibility of a significant effect on the environment. And with that, we are happy to answer questions. And I believe the CEQA consultants are available on Zoom. Yeah.
The CEQA consultants are available on Zoom, and so is the building official, Brian Banson.
Thank you. Would you mind backing up one slide just while that's up there while we ask questions? Thank you. Any questions for our city staff? Would you go first, please?
I think we all have so many questions, but I'm going to start with a first question, which isn't actually mentioned here, which is that item 1 of the 5 criteria is that the project is consistent with the applicable general plan designation and all applicable general plan policies, as well as with applicable zoning designation and regulations. And so my understanding there is that if we say that is true, we are saying that the apartment building as part of the project is consistent with applicable zoning standards, taking into account the density bonus to which they are allowed. Is that correct?
That is correct.
Okay, so is that something that we should be adding to this list? Because that wasn't something that the planning commission necessarily touched on, but is that something that we need to be discussing this evening
Yes,
as
I
well?
think I think it would be appropriate. It was raised in one of the letters.
Okay, and I'll ask just one additional question because I know other council members will have a lot of questions. I just wanted to understand or clarify process here in terms of how the memo recommending that the applicant was exempt from further secret review came about. So my understanding was the applicant asked for the class 32 exemption. City staff did some initial work. The applicant submitted some initial reports beyond what we would normally ask for any other types of exemptions. We then brought in Ascent as an outside peer review agency, effectively to review the reports that had already been submitted. They then asked for a lot more reports, clarifications of reports, and after a very lengthy process, reached the conclusion that with all of those reports, they were eligible for that exemption.
That is correct. That is correct, yes.
So just to clarify, because I think there was some confusion in the planning commission meeting, it was never their job to get out on the lagoon and look at anything because the various reports that were compiled beforehand, it was those various entities that went out on the lagoon, whether it was geotech or whether it was biological resources. Those studies were done by the relevant agencies, organizations, and Ascent's job was to review all of those materials, ask for additional materials, and reach the conclusions.
That is correct, yes.
Within that, did they, in reaching their recommendations, did they make the assumption that the bulkhead would be replaced in its entirety?
Yeah, I can pass it over to Mike Parker at Ascent, but yes, they did assume that the bulkheads were going to be replaced in their entirety because that was the most conservative approach in terms of their CEQA evaluation.
And their conclusion within that was that with all of the permitting that is required as part of replacing bulkheads, that there was no risk of contamination of waters or any other environmental impacts.
That is correct, but I'd like Mike Parker from Ascent. That combined with the other regulatory agencies' review, they came to their conclusion, but I think he can answer it
okay, thank you.
well. And he's here. Mike, you can talk now.
Sorry, my screen just disappeared and I wasn't sure what was going on. Could you repeat that question? I was trying to figure out how to join the meeting.
Sorry,
my apologies.
I'll ask the last part of the question, which was that as part of your review, to be ultra conservative, you made the assumption that the full 900 linear feet of bulkhead would be replaced. And even with that, you made the conclusion that with all the various city and other regulatory agencies, that there was no possible impact on water quality.
Yeah, I'd have to go back and check to see if we assumed the full like 900 feet of bulkhead replacement, but I know we did assume that bulkhead replacement would occur. And with that, we did conclude that there would not be water quality impacts. And that's due in large part to just the sheer amount of regulatory requirement for any work near this feature. So I'm not sure if, and I don't think that there would be a difference between how much of the lagoon frontage would be affected.
Okay, I think that clarifies it. Thank you. And so just to put that into context as well in terms of the type of work that goes on in the lagoon, and I know we have our building official here as well, replacement of bulkheads is commonplace in the lagoon, correct?
Yes, it is.
And so can you, how many bulkheads are replaced in any period of time?
Brian, are you there? I think we had about 16 in the past 10 years, but let me have Brian verify that for me. Brian Vanson? Can you talk now, please? I can pull up an email if you have another question, or there he is.
I'm here. Can everyone hear me?
Yeah. So Brian,
Fantastic.
it was just how many bulkheads have been replaced in the past? I don't know how many years.
I believe that the research we did earlier today had 20 bulkhead replacements in the last 8 years. So 2.5 per year.
So 20 replacements, and the average lot size linear feet is about 100 linear feet. So that's about 2,000 linear feet of bulkhead replacement in the last 8 years.
Yes, with that assumption of the width of the property. They vary, but yes.
Right. And can you, it would be good to know, firstly, the permitting process that goes through, and then also just the what happens, what is actually the engineering that takes place during that that bulkhead replacement?
Yes, so it depends on the proposed bulkhead, the material. Different materials will have different engineering. The previous building official had worked with the BLPOA to streamline or create a standardized process for vinyl bulkheads with engineering backed by a local engineer. Normally that process, the application would be submitted. We would review the site plan as well as the engineering, which is standard. And we would also now send that project or require that applicant to obtain regional water quality resource board approval and Army Corps of Engineer approval. And we would not issue that permit until we receive those approvals.
And then the process itself of implementation, what mitigation is automatically done to make sure that there are no impacts on the water quality?
So that is dependent on the site and the possible percentage of any type of contaminants going into the lagoon. There are local and state requirements that place the responsibility onto the contractor, and they are to mitigate basically what they call illicit discharges or any erosion of the existing grade. And so those may be a type of silt curtain placed in the lagoon around the proposed scope of work. It may be netting placed on the existing grade to prevent stormwater or rainwater from eroding the existing land once the bulkhead is removed. It could also entail cutting back part of the existing grade kind of to an angle of repose almost while the work is being done, as to not create a steep cut or a high percentage of any type of dirt coming into the lagoon or any surrounding area. This is standard on any construction project.
And so this would be exactly the same protocol for this project. It would be the same, except that now we also require Regional Water Authority board approval, as well as Army Corps of Engineers, who put in place extremely stringent requirements which the city and the applicant would have to follow. And hence, that's the reason why I'm assuming Ascent reached the conclusion that there's no impact on water quality. Does that sound right?
Yes, we would require the same standards. The standards are the standards. Every project is subject to those standards. And depending on, speaking in the context of the state, depending on the size of the project, the standards may actually become more restrictive the bigger the project gets. The project may require to have a SWIP, which is a stormwater pollution prevention plan. And it would be more stringent than just, say, the construction of a single family residence.
Okay, and this all gets established during the permitting phase. This would be the same for this project as for other projects around the lagoon.
Correct.
And we've successfully replaced about 2,000 linear feet of bulkhead with no impacts.
Correct.
Okay, thank you.
Can I-
Awesome.
Before we move on, can I back up to Councilmember Wilkinson's first questions about criteria number one? And not so much getting into the qualification of it, but that its acceptance would identify the project as consistent with zoning and general plan regulations going forward. As I understand, right, that was the question.
The project includes excuse me, the project includes requests for waivers of development standards and for a concession to allow the apartment house to be built. Court decisions have said that that zoning standards that are waived are not applicable to the project. And the language of the exemption is that applicable zoning standards, the project must comply with applicable zoning standards. So if the project is entitled to the concession, then the zoning standards are no longer, the prohibition on apartments is no longer applicable to the project, and it qualifies for the exemption.
I understand. The case and the process that we're going through now is
Right.
determining the CEQA exemption.
Correct.
Very specifically. And the case I think you're referring to talks specifically that waived zoning standards and presumably given current law and current momentum, modification of zoning codes via concessions, which still to be determined, are not applicable, and that the requirements of this criteria would therefore be met. That's what it says, I
Correct.
believe. But that has no implication on its consistency going forward, because it's identified those waived and conceded standards or potentially zone regulations as not applicable for the purposes of the CEQA exemption.
Yes, that's correct. They're not applicable for the purpose of the CEQA exemption.
So how is it presumptive for, I understand there's a separate analysis for that from a planning perspective or for an acceptance of a waiver or a concession, but how is this activity, should it happen, considering that it designates it as non-applicable for the criteria being considered? How does that presume to deem it consistent for planning purposes later?
I'm not sure I understand the question.
Yeah, I'm just asking the question that it seems that if findings can be made for number one in the criteria,
Right.
that you seem to indicate that would remove any potential discretion the planning commission and the subsequent city council would have for determining consistency with general plan zoning and regulations and zoning regulations.
Well,
That alone, I'm saying, I understand that there are plenty of other cases, plenty of other statutes, in particular, statute section 6915 subdivision E, which makes it very clear about concessions and waivers and some other things relating to housing density bonus law. But you seem to indicate that this qualification alone would deem those consistent.
well, there was, the staff did a pretty detailed analysis when the project first came in about whether the project was consistent with the zoning and the general plan, and sent, I think, 2 letters to the applicants pointing out various inconsistencies between the zoning and the general plan. So there's two issues. First of all, so the applicant responded to the inconsistencies in some cases by changing the project, and in other cases by applying for waivers and a concession. And that, those 2 mechanisms basically dealt with anything that the staff had pointed out. But a different law, the Housing Accountability Act states that if the staff did not point out inconsistencies with the general plan in those 2 letters, the project at that point is deemed consistent with the general plan and the zoning and all planning standards. So there's several laws that the state has been imposing that first of all, if the staff doesn't point out an inconsistency with the general plan, the project's deemed consistent. And then secondly, if it's not consistent, they can apply for waivers and concessions in most cases. And then this other case, the Walmer case, says in that case, the standards aren't applicable to the project. And
No, I understand completely. I'm just trying to
so I'm,
parse it somewhat from the perspective that it may be a foregone conclusion. I'm not saying it is, but it may be a foregone conclusion that housing density bonus law and HCD and other regulations will ultimately deem that project consistent from a waivers and concession perspective. All I'm saying is that would a finding that the project qualifies under number one of these 5 criteria
Yes.
alone and exclusively deem it consistent for the remainder of the project? I can't imagine that's the case. It may be a difference without a distinction, but you seem to answer that this alone, we would be forever dictating that determination based on our decision tonight.
well, I think the decision about whether it's consistent with the general plan or not, the only issue, I mean, it's essentially state law has decided for the city that the project's consistent with the general plan and the zoning. That would be what I would state.
Can I just ask?
I'm sorry if I'm
Yeah, no,
missing,
it's,
if I'm missing the issue.
I'll
Mayor.
move on. I think we'll probably get back to this at some point,
Yeah,
but
yeah.
If I could sort of ask something, I guess maybe we're a little confused because the title of the resolution is that we are being asked to decide to approve or deny an appeal, I think.
Correct.
And the appeal is focused on the 3 areas that you showed us in the slides. So I guess what I'm asking is, I thought, maybe I'm wrong, but I thought that because it said we were voting on to deny or approve the appeal, not starting all over again on the whole Class 32 decision. So I guess my question is, are we replacing the Planning Commission, or are we voting on the appeal that came from the Planning Commission decisions?
Your decision is, I'll turn to the city attorney if I'm wrong, but my understanding is that your ordinance says that the city council's decision is de novo. And so that you can make, you're like a court and you can make your own determinations.
Yeah, I can confirm that's correct. I mean, the city council is not bound by the planning commission's determination, nor does the city council need to give the planning commission's determinations any special deference. But the staff presentation and I think the letter from the appellant, did focus on those 3 issues that both Rebecca and Barbara went through. And so that was where we suggested the analysis and discussion should start.
Yeah.
But that obviously is not binding on the city council either.
But then how, without any other background information, and since it was not discussed at the Planning Commission, if we are unfamiliar with the zoning, et cetera, applications, what Barbara was referring to between the city and the developer, we have no information on that. How would we possibly reach a conclusion?
Yeah.
Certainly, it's up to the city council's discretion as to which decisions it feels comfortable making tonight. We did discuss, I think, somewhat extensively the issue of general plan consistency and zoning conformance. But that was not, at the center of the appeal. But certainly the appellant can also address that issue as well, if he
Yeah.
has a different view.
We also attached the Planning Commission staff report, which has a pretty extensive discussion of this issue.
It's at page 12.
Thank you.
while you're speaking, do you have questions or do you want to?
I was wondering if the San Francisco Bay and Richardson Bay are considered urban use.
I don't think we've had that opportunity to determine that.
Okay, so you have no idea if it is an urban use or not?
Uh,
I thought I
mean,
had
I could
heard
give you
that
my
it was not
personal,
an urban use.
I could give you my personal opinion, but I
Okay,
haven't looked at it in any kind of context. Probably not, but you know.
okay. I think I'll hold off, thanks.
Councilmember Lynch?
Just briefly, my colleagues have asked most of the questions that I had, so this will be brief. We received a number of letters, all of which I'm grateful for, but a couple of them, I think this question is directed maybe to Rebecca or to Robert. A couple of them raised, apropos of the bulkhead question, raised the question of the city conducting a full EIR for the seismic upgrade project. And at least at the planning commission level here, proposing, and I think here also proposing that this project could proceed without a full EIR for bulkhead work that needs to be done. And my understanding is that some of the techniques and materials that are used for sheet piling for the seismic upgrade are similar in kind, at least to the bulkhead work. And the suggestion in this correspondence we received is that that is an inconsistency. And I'm wondering if one of you can address that, please.
Well, I can start off, and Rebecca, if you want to add anything, that's fine. I think it's a fair question. The seismic upgrade project, given the scope, the length of that project at over a mile long, and its location, San Rafael Avenue and Beach Road, its proximity to the Bay waters. It was determined when we were looking at whether or not that project qualified for a CEQA exemption under existing structures, modification of existing structures. It was better safe than sorry to go with the EIR in that case, just given potentially the way the community was feeling generally about those improvements. You know, there were potential impacts to aquatic resources in those areas. I can't say whether or not that's the same for the lagoon area, but I think it's probably lessened because they're not in direct contact with the bay water.
I think that's you sort of hit the nail on the head with that. That project is connected to the bay waters, and the extent of that project was very different than what we're looking at here in terms of our bulkhead replacement. I also think, and Robert, correct me if I'm wrong, that the bulkheads in the lagoon are typically vinyl, and in the Protect Belvedere EIR, it was all sort of metal sheet piling and metal piles, which are different materials.
That's correct. And if you recall, a major component of the seismic upgrade project was seismic, right? So we were going with engineers' recommendations to strengthen our levees by driving those deeper and using more heavy duty materials. Again, yeah, because of that, the size of the project, potential impacts were higher, and decided to be cautious about it.
Thank you.
One more thing quickly to add also in that the Protect Belvedere EIR, those sheet piles were going 40 to 60 feet into the ground. Typically, after a discussion with the building official, bulkheads in the lagoon go 6 to 10 feet into the ground. So I think just given the difference in the sizes, it's comparing sort of apples to oranges.
Thank you. One other question I had about bulkheads, following up on the questions from Councilmember Wilkinson. What I understood the assent person to say is that there will be an examination. There will be steps taken to mitigate water quality problems from bulkhead work. My question is, would any bulkhead work be done before heavy equipment starts digging and drilling and doing piles on that lot, or will a judgment be made by the professionals about what bulkhead work needs to be done, if any, and at what time?
That might be a question for either Brian or the applicant, just about their scoping of the work. It is a.
I think it's a fair question for the applicant. I certainly think should the project eventually go to a planning commission, a condition of approval could be put into construction phasing and maybe sequential demolition and sequential bulkhead construction, but that would really be a fair question for the applicant.
Thank you.
Following off from that, even if it isn't, if after all the studies are done during permitting, it isn't a full bulkhead, isn't technically 100% necessary, the planning commission or the city could still require full bulkhead replacement as a condition of approval. And as you say, schedule that to be first as part of the project if it was felt that that was necessary.
Yes, if the applicant would agree.
If the applicant would agree. Okay, thank you.
I just had one other follow-up question for Brian. When he was responding to Councilmember Wilkinson, he said that the state requirements come in for every project during the permitting phase. And my question is, our state, because the lagoon is under federal and Fish and Game and several agencies, are you saying, or is Brian saying, that all those agencies give their input automatically, or do they only give that when requested due to some kind of an environmental review?
City of Belvedere requires that any any bulkhead repair replacement in the lagoon prior to the city issuing a building permit, they are required to go to Army Corps Engineer and Regional Water Quality Board. So it would be prior to issuing a building permit. We wouldn't issue it until those regulatory agencies weigh in and those conditions are met that they're asking for.
But you're speaking specifically about bulkheads.
Yes.
Oh, okay. Sorry. Thanks.
And docks.
Sorry.
And docks would be
Docks,
subject,
yes.
yeah.
Anything else this time, Tim? If I could, Barbara, follow up on a couple quick points you made. When you were, no, I mean, separate subject, I won't go back there. You talked about the definition of urban use and how Bankers Hill, utilizing a definition, I believe, drawn from Friends of Mammoth, identified urban use more about the location than the actual use itself. And then you referenced subsequent definitions of substantially surrounded and qualified urban use later, in fact. Did those subsequent definitions have any altering effect on, that precedent on municipalities' definition of urban use? Is Bankers Hill utilizing that Friends of Mammoth definition still the de facto reference?
Yeah, Bankers Hill is still good law. Neither of those definitions, when those definitions were adopted, they did not apply specifically to the urban infill exemption. So Bankers Hill remains good law unless some future court changes it.
Okay, thank you.
Yeah.
And secondly, in your slides, you talked about criteria number 4, that the approval of the project would not result in significant effect relating to traffic noise, air, or water quality. And you've gone back and forth a few times between that language would and even the word may. And I'm trying to understand. I understand may is the consideration under the exception down below under the second exception possibility of unusual circumstances, but may seems to be completely in conflict with would or would not.
I agree with you, and we frankly have had kind of trouble sorting out these two different standards. I would say that that if there are unusual circumstances, there's what would I call it? Less evidence is needed to find that there may be a reasonable possibility of substantial evidence that there may be a reasonable possibility of a significant impact is quite a low standard. That's the standard that's used to decide if an EIR is required, that there may be a significant impact, correct? The language in the language that there would is whether there is substantial evidence that there would not be a significant impact on water quality. So I guess it would be conceivable that there would be substantial evidence that there would not be a significant impact on water quality, yet if there was an unusual circumstance, maybe there would be substantial evidence that the project may have a significant impact on water quality. Frankly, it's a very confusing set of standards to the attorneys as well as to the public. I understand, but that's kind of the best we can do.
I understand the possibility or in relation to an impact related to CEQA. But if we're asked to look at a specific qualification for an exemption, this seems to be pretty specific. And can you also comment on the directionality of it, if that's meaning that if there's substantive evidence required to find that there would not result in any significant effect related to traffic noise, air and water quality, and you've already said that there can be substantive evidence that it would, but that's not to be considered. it's you have substantive evidence that it would not. Is that direction aspect of it correct in that argument?
The city council as a fact finder is allowed. I mean, there can be substantial evidence that there would not be significant impacts. And there could be substantial evidence that, I guess that there would be. It's not clear how there could be substantial evidence in the other direction.
So
you are entitled to make a decision and to describe what evidence supports your decision.
Okay, thank you.
I'm going to ask a couple of additional legal questions, Barbara, I'm sorry. So we grant various exemptions, not just a class 32 exemption in Belvedere. There's an exemption for single family homes, a class 3 exemption, is it correct? And that also has the same exceptions, correct?
Yes, it does.
So if there's unusual circumstances in those cases, they also require further CEQA review.
Correct.
So here's my question, that if the unusual circumstance that many people think exists is relating to failing bulkheads, would that not also imply that every property, single family home in Belvedere who wanted to replace their bulkheads would also require an initial study? Because if we were to deem that this is an unusual circumstance, that for a 300 linear feet, for example, large lot that was replacing their bulkhead, would that also be deemed an unusual circumstance?
There are, obviously each case would need to be looked at case by case. I don't think you could necessarily make a blanket statement. Also, the staff informs me that the bulkhead replacement, if someone only comes in for bulkhead replacement, it only requires a building permit. Is that correct? In that case, it's considered a ministerial approval. And ministerial approvals are exempt from the California. So much would depend on the type of approval that was being requested and probably the particular circumstances.
But in the example where it's a demolition, full replacement of the bulkhead, rebuild, there's a good probability that if this applied in this case, that it would apply in those cases as well, and we'd require further study from.
That is a potential, yes.
Okay, fine. And here's my second area, which is as I understand, the class 32 doesn't define what substantially surrounded by urban use means. And so we've drawn, or at least there's an argument drawn, that substantially surrounded has been defined somewhere else within CEQA. And that is the Public Resource Code 21159.25, which is an exemption related to housing development in unincorporated county land, correct?
Correct.
And this is the only way that place it's been defined, and it's defined as at least 75% of the perimeter is surrounded by qualified urban use. But this standard, this new exemption was only introduced in 2019 and sunsets in 2025. And so my question to you is, when the Class 82 has existed since, did you say 1998?
Yes.
And there's a lot of case law that says this is the definition of urban use that you should use because it's not defined anywhere. Why would we suddenly pull from a new temporary definition? In this definition, it specifically says that these definitions only are for the purposes of this section. It specifically says that in the code. Why would we draw from that as an alternative when it's very clear from all of the case law and from the history that you actually go to the case law to establish what urban use means?
Well, there's not really any definition in the case law about what substantially surrounded means. So we
Right.
were looking for,
Anything?
anything that might provide some source of authority. For instance, the Mammoth decision that the Bankers Hill case relied on it was actually a redevelopment case. It wasn't related to, so sometimes courts do that. That's why we looked at that.
Even though it
but-
specifically
but-
says it's just for the purposes of this
Yeah,
section and it's a
I
5-year
understand,
clause?
but the courts sometimes look for, any port in a storm, any straw. But I don't think that really is not really the issue because the issue in this case is really whether the lagoon's an urban use or not.
So
I
the-
don't think the substantially surrounded is an issue.
Or the qualified urban use, which is sort of the definition that comes in here in terms of it says substantially
If-
surrounded is qualified urban use, but this is a subset that's specifically applied to this one exemption, which is a temporary exemption related
Right.
to unincorporated
Right.
land.
There's a variety of other exemptions that also use the 75% standard,
Okay,
but they don't call it substantially surrounded.
okay,
So, yeah.
thank you.
Just carrying on with that topic, because it's certainly a confusing one, obviously, for everyone. I came across the Governor's Office of Planning and Research that did a CEQA review of housing projects technical advisory. And they actually have a comparison list of all the exemptions. And then they don't define urban use. They make it very obvious that there is no definition for urban use. But it seems to me that if we're looking for ways to define, I'm wondering if you're familiar with that technical advisory and if that's something that is appropriate to look at for help with defining urban.
I've seen that advisory, although I don't have it in front of me. Yeah, I think you can rely on, whatever you think is an appropriate source of authority.
Okay, well, I guess one of the main issues about this is that the governor's office defines an urban area as 100,000 people or more.
Oh, that's,
So I'm curious how this all fits in.
I'm sorry to sigh.
That's okay. We're
There
all
are,
sighing.
there are several definitions that's a definition of urbanized area. And so that's used for various, that's used, I think, anyway, it's used for some exemptions, and that definition is a community of 100,000 or more, or one that's bounded or has two communities bounding it where the population of all three equal 100,000 or more. In several of these aren't in CEQA, but in several of the housing bills, there are definitions of urban area. They use definitions of urban area established by the U.S. Census Bureau.
Mhm.
So I think there are anyway.
So
I
it depends if we use the
think-
governor's office or the US Census? Is that
Well,
what-
that definition of urbanized area is in the Public Resources Code and applies to certain.
No, I know, but it also mentions urban area, not just urbanized area.
Right, right,
I do see urbanized area,
right.
but there is a separate definition for urban area.
Right.
So,
I would say that
okay.
in general, if you look at the cases on the class 32 exemption, I don't believe any of them have ever used, they look at, have ever used this definition of urbanized area to determine if a project is eligible for the class 32 exemption. Yeah.
Okay.
That would limit it, that would substantially limit it.
Just to follow up once again, and I'm still a little befuddled why we even went there. If Bankers Hill and utilizing Friends of Mammoth, distinction and definition of how a use is quantified relative to urban or not is good law, why would we have gone anywhere else?
Well, we thought it was good law, but we thought it wasn't definitive in terms of the lagoon. And we're just looking for other, other
Okay.
sources of direction.
Okay, perfect. Thank
Yeah.
you.
Yeah.
Any more questions before we move on to the applicant presenting? Sorry, the appellant to presenting? Seeing none. Like now turn it over to the appellant for their presentation.
Okay, I think we've resolved all our technical issues. Good evening, Mayor Mark and council members. On behalf of the developer, Mallard Point 1951, I want to state our commitment to the delivery of a high-quality, well-designed, mixed-income housing community that meets the needs, standards, and desires of Belvedere and its residents. To get there, we've worked closely with your staff, and I do appreciate their efforts, particularly in light of the housing element rezoning and all holidays and all the other activities to get here this evening. Relative to Mallard Point, this project must be socially, economically, and environmentally sustainable. Relative to this last item, environmental sustainability, we are here tonight to address our appeal of the decision of the Planning Commission to deny the Class 32 exemption for our property. We believe this decision was incorrect for a variety of reasons that we will review. As this is largely a technical and legal discussion, we have available members of our consulting team. Our biologist, First Carbon Solutions, is on the phone tonight, and they're represented by Jason Brandman. Our civil engineer, Chris Mills of BKF Engineers, is also available by phone, and our geotechnical engineer, who was also retained by the city for the San Rafael Road infrastructure improvement, Scott Stevens of Miller Pacific, is here. And finally, I want to turn this presentation over to our Land Use Council, Riley Hurd. All of our team is available for any questions that you may have. Thank you.
Good evening. My name is Riley Hurd, and I'm here on behalf of the appellant, who's also the applicant. We're here to talk about a really narrow issue tonight. That's a Class 32 infill exemption. It's highly technical. This is usually addressed by specialized experts outside of this forum. So forgive the legal speak you will hear. But before I dive in, I would like to acknowledge the elephant in the room. We are only talking about this because it's the last bastion of hope for those dead set on preventing this project from being built. Otherwise, we're not talking about this. Homes get built all day on the lagoon. So slowly but surely, the state has eroded local control over new housing. This project must be approved. So that is why you see the fight focused on CEQA. It's been weaponized. It's nothing more than that, and we need to call a spade a spade. So CEQA is an informational process about environmental effects. There are broad categories of exemptions for projects that don't have significant impacts. Usually if it's exempt, that's it. Nothing else happens, you move on. The infill exemption is different though. It's unique. There's 5 categories that get studied. It's supposed to be somewhere between an exemption and a full environmental review. Here, erring on the side of caution, this exemption ballooned into a multi-year 6-figure environmental investigation. This was not just the required categories, but any and every potential impact that could be an exception to the exemption. The substantial evidence is rife. Now, this process totally undermined the purpose of an exemption. It's supposed to make it faster and streamline it. But what it did do was make it absolutely certain that there are no significant effects from this project. Otherwise, you couldn't use the exemption. And this is really important because the only thing that would come from further environmental review is more cost and delay, not new protections for the environment. A project at this size cannot sustain those costs and delay, and that's exactly what the opposition is counting on. So the primary opposition is that the man-made lagoon is not an urban use. That might have been true 80 years ago, but not anymore. This lagoon was created by bulldozers that scraped up the floor of the bay and used that mud to make the peninsula and shores that are now totally developed. I found these pictures amazing. I think you'll hear more from the Allens about the history of it, but this is the lagoon under construction. The water only comes in and out a couple times a year. It is not open and free flowing to the ocean. Every year, the BLPOA dredges this lagoon, removes material. They dump algicide into the lagoon. They remove any plants that survive that. This is specifically intended to keep the lagoon from returning to its natural state. I would hope that this is not how an actual environmental resource would be treated in Belvedere. Furthermore, the lagoon is a citywide stormwater detention basin. It's a public use. This is acknowledged as shown on the screen. It's a very important fact. Next, what is an urban use? Here you see that the lagoon sits smack dab in the middle of a city, connects 2 parts of it. You can see also the construction of it on the left-hand side. You heard about Bankers Hill. In that case, a park was found to be an urban use because it was contained within a city. It's not an adjacency question, it's a within question. They looked at Friends of Mammoth. They said a park was an urban use because it was surrounded by populated areas, just as we see here, and was an urban amenity, just like the lagoon is acknowledged to be. There was another case that also had Bankers Hill as a plaintiff. They do a lot of suing down there. And they looked at whether a park was part of the natural environment or not, again. And in that case, the city's general plan said that that park had been modified and that it was no longer natural. Belvedere's general plan says the lagoon is considered a low quality habitat and the general plan calls it a recreational facility, quote unquote. The court gives great deference to the statements you make in your general plans. There are other lagoons. There are many exemptions used, Foster City, Larkspur, the list goes on. Councilmember Cooper brought up the OPR guidance on the definition of substantially surrounded and urban uses. It is correct. Our column 15332 says that it's not defined. There's a red arrow pointing to that. However, we've received many letters about the second column, which doesn't apply here, which has to do with the 75% requirement. And I actually agree with Ms. Couts that we do often in the law, when we don't get answers, look around to see how it gets treated elsewhere. So let's do that, particularly because you've received so many letters about it. We're talking about the infill exemption. This is the definition of an infill site, and it means either A, the site has not been previously developed, it's vacant, and it's 75% surrounded by urban uses. That's the one you keep hearing out of context, but please read B. An infill site is the site has been previously developed for a qualified urban use. What's a qualified urban use? Residential. This site is already developed with residential. It's a qualified urban use. It's an infill site. You want to talk about the lagoon? That works too. Public institutional use, it's a detention basin. This is just being thrown out to confuse. It's working, but if you read the whole thing, this fits the definition of infill precisely. Water quality. I've heard a lot about this. This project's going to have less impervious surfaces. It's going to have bioswales for the first time, treatment of stormwater for the first time. And I think this is where the action is. The regional board now is looking at this, Army Corps, Fish and Game. We have to do a SWIP, which is a stormwater pollution prevention plan. This cannot have any impact on water quality. It simply can't. And that is made sure by these agencies. The Regional Water Quality Control Board has a very specific permitting process, and they won't issue the permit if there are not BMPs and measures in place to prevent impacts. And this dovetails with the bulkhead and the geotechnical issue. First of all, I want to let you know our expert is here. Please bring him up during the Q&A period, ask every question. But I think what's key is that this isn't unusual. Development in these conditions occur all over the Bay Area. There are multifamily developments already on the lagoon. The fill here has settled. There's no evidence of unstable soil. I do not know why that keeps being brought up. And I want to talk about the bulkheads. First of all, the 900 linear feet is not all bulkhead. Okay, there's riprap, there's shore, there's no evidence that it is settling or that there's a problem there. That being said, if during the building permit application, the city says you need to replace this, we have to do it. And we have to go to every single one of those agencies now. That's the new Pandora's box that's been opened to try to fight this project, is now everybody's got to go do this. They're not going to let you do a project where there's sediment going into the lagoon or you don't have measures in place to prevent that. So this happens all the time as part of full rebuilds, in isolation, and the lagoon is fine. Okay. Environmental review was done for your housing element. And this outside consultant found something very important. Geology and soils and hydrology and water quality, they weren't listed as potential impacts that could be mitigated. They were listed as not potentially affected. And folks are saying, oh, that was just a program level mitigated negative declaration. First of all, there's no such thing. You can only have a program level EIR, not an MND. Second of all, the project description that found no impact by this outside consultant wasn't just the housing element, but it was the rezonings that you approved tonight on your consent agenda. Those rezonings allow for ministerial approval of housing projects on the lagoon. So when that consultant said there's no impact, he's looking at housing projects on the lagoon. They will not be subject to future CEQA review. So I'm just letting you know that because that's how it works. The housing element. Belvedere has told the state that the bulk of the housing is going to go on these highlighted sites, all right around the lagoon. And as we discussed, the mitigated neg deck said that's not going to have an impact to geotech or water quality. So my question is, if we can't do a net increase of 18 units, how is this possible? And how is the state going to accept that the housing element is real? Okay, the days of kind of hide the sites and hope it doesn't get built are over. Right now in Beverly Hills, they just lost a court case. They cannot issue building permits in Beverly Hills until they have a certified housing element. It's very punitive. HCD is not just a voice in the room. The courts are saying HCD decides when you're in substantial compliance. And that happened in Calabasas, that happened in La Cañada Flint Ridge, and it's going to start happening up here. So this project is the canary in the coal mine for the realistic likelihood of the housing element to proceed. All eyes are on it, and requiring higher levels of environmental review than are allowed by law is not a good sign. So this is one where I think you need to trust your experts. So at the Planning Commission, the city staff, the city attorneys, Ascent Environmental, and 2 outside attorneys reviewed a staff report that said this project should be exempt from CEQA. Now it's true, the PC went a different direction, but you can't walk back that recommendation from the professionals. The housing element CEQA expert found something similar. Even the person that prepared the EIR for your seawall project unilaterally wrote in a letter and said, I've looked at this project's exempt. I thought that was really, really powerful. I've used this exemption on projects with hundreds of housing units. There is nothing unusual about this. So we'd ask that you do not fall for the subterfuge, the confusion. I think the city is actually lucky to have Thompson Dorfman doing this, and to run them out of town would be a big mistake. I've seen the other projects that are moving forward under things like SB 35 and Builder's Remedy and others jurisdictions, and they look nothing like this. We'd ask that you grant the appeal, talk to our experts. I have extensive additional legal briefing on the issue of the density and compliance with the general plan and zoning. So if you'd like to talk about that, I'm happy to do so. But I think those are the key points. Thank you. If you don't have any questions, sit down.
Thank you. Do we have questions for the appellant? Want to go first?
Good evening. Thank you for that presentation, and thank you for all of your input. It often directly clashes with a lot of the other input we've gotten, but it helps those of us who are trying to get to the bottom of it join the issues. And so I appreciate all the effort. First question is, does this site include wetlands?
This site does not include wetlands. Everything that's occurring as part of this project description is on dry land. All the work that is a part of our application is on land.
Does that include any docks that get built, or is that later? And how does that intersect with bulkhead work?
Yeah, great question. So the docks, they're coming later. They're floating. Yeah, okay. Yeah, I mean, I guess it depends on whether you consider the lagoon a delineated wetland or not. But like the rest of the development around the lagoon, there will be some number of docks as exists today.
All right. And so putting aside whether all the work happens on dirt or not, do you regard the lagoon as a wetland?
Let's see. I don't think you could put algicide in a wetland. I don't think you could dredge a wetland. So I don't regard it as being treated as one so far.
Okay. I don't know the answer. This isn't rhetorical. I'm trying to figure it out
I
because,
completely understand.
yeah,
I
okay.
can let you know that wetlands are extremely protected, designated delineated wetlands. And I've never heard of someone being able to dredge a wetland or put poison in a wetland or pull plants out of a wetland.
All right, thank you. The council who represents Brig has said, among other things, has said, or I've read multiple times, that the Army Corps has jurisdiction over this body of water. And I understand that to be correct. What am I supposed to do with that information? What's your perspective on how I should treat that information?
Yeah, so I mean, just being honest, dealing with and getting through the alphabet agencies that we call them in the industry, US Army Corps, Regional Board, Fish and Game, it's extremely difficult. And the why to that is they're extremely conservative. So if you're sitting up there and asking me what to do with the fact that permits from those agencies might be required, and just so you know, that's absent the CEQA status, okay? You go there if you're exempt, you go there if you're not exempt. All of that still happens. So what do you do with that? If you're interested in lagoon protections, I think you can find great comfort in that fact.
Okay. Last question is, there's been debate, and I know that all the lawyers around here and even the non-lawyers have been trying to figure out urban area, urban use, urbanized area, and so forth. And there's a number of those definitions that appear in the statute, and they apply in certain limited circumstances and so forth. Are you familiar with the one that appears in the regs for urbanized area? And do you consider Belvedere an urbanized area under that regulatory section?
I'm familiar with the two definitions that I covered this evening. One is set by case law, and one is admittedly comes from a section that doesn't apply here, but we are looking to it for some enlightenment. I mean, that one is extremely clear cut, but I agree it doesn't apply. And I find Bankers Hill 1, Bankers Hill 2, as well as Friends of Mammoth to be pretty dispositive on the issue.
Okay, if you catch a break tonight, maybe you can take a look at section 15387 of the CEQA related regs. And if you have any input on that, that'd be helpful.
Sure, I think I'll be up here a couple more times, so I'll take a look.
Thought you might. Thank you. Appreciate it.
I guess following up on what Jim was just asking, which I don't know 15387 either. So I don't know if you're going to explain it to us, Jim, but I know that Mr. Hurd used this technical advisory review that I had been discussing. And I guess I'm confused because the definition of urbanized area is the 100,000 in this. And then your 21061.3 infill site area means a site in an urbanized area. So are there different definitions of urbanized areas? You were using the same sheet I was using.
No, we're on the same page.
But this says an urbanized area has 100,000 people, which obviously Belvedere does not. So that's the meaning of urbanized area on this review of housing technical advisory.
I completely agree. But you know,
So the
that's not the
infill
criteria.
site that you're talking about is dependent on it being in an urbanized area, and Belvedere's not an urbanized area.
The definition of infill site that keeps being referred to by Briggs' attorney and others is where they've cherry picked the 75% rule. So yes, you're right. It doesn't apply.
Okay.
So if we hear that, just know it doesn't apply.
Okay.
Because you're right. Urbanized areas.
I'm sorry. I thought you were using, I thought you were telling us what an infill site was.
I looked to the
And that you were
definition.
using that as an example of that the project is an infill site. And then because you were using the same technical advisory, I assumed, I thought maybe we were on different pages.
Good question. That column in the OPR memo, on its very face at the very beginning, does not apply to this project. So if you want to hold it up and say it's the 75% rule because you're against the project, too bad it doesn't apply. If you want to say, hey, great news, it says that an infill site is anything that had residential uses on it, too bad, doesn't apply. It applies to both sides.
Okay, got it,
equally.
got it.
My point was Ms. Couch says, hey, when we don't know what an urban infill exemption means, where do we go look? Well, we know that the urban infill exemption doesn't just have to be in cities of 100,000 or more. It's used widely all over the place. So it was.
I wasn't sure if it was. That's why I was asking. I don't know. I have no information to know.
Yeah, I mean, I've recently done a 168 unit project subject to the urban infill exemption in Marin County in the incorporated areas. I've used it for many other places and populations well under 100,000. But I think we agree about what an urbanized area is
Okay.
in that context.
Thank you.
Please.
Have you completed any projects where you have built on protected waters?
Well, it's interesting. It's no longer up. I can tell you that Thompson Dorfman has, and they're.
I meant the applicant. I didn't mean you personally.
Yeah, okay, great. Yes, my understanding is they have completed 7 waterfront projects, all throughout the Bay Area, all to completion, and never A, facing this issue, or B, having any resultant environmental problems. They're functioning, beautiful developments.
So there's never been any contamination of any waters during, no. What would be the consequences for the applicant if they did contaminate waters? Meaning what happens?
Yeah, so the agencies that we're talking about here have very stiff penalties. Those come both in the forms of monetary, and there can be other, in extreme cases, you get over into the penal code and things like that. There's licensure problems that particularly runs to the contractor. So that is also very important to consider. And there's strong enforcement arms. I mean, these agencies, like I said before, they take this extremely seriously.
So it is in the interest of the applicant, the financial interest of the applicant to do this well. And I guess my question is if there was some kind of contamination issue, I'm assuming that the ability to get financing in the future for projects would be in jeopardy if you were behaving as a bad actor.
Well, you get a red tag, you get red tag not just by the city, but by these agencies. And so time is money when you're building one of these out, particularly one like this. This isn't a decades-long, large-scale development project. It may feel like it's being treated that way, but this is a really small project.
Okay. And this was actually just a question of interest more than anything else. Why did you not do a bigger project?
Yeah, that's, I probably will defer to Thompson Dorfman on that, but I can tell you a couple things that I was involved in about why we didn't upsize the project, and in fact, did not avail ourselves of the density bonus, the full density bonus to which we're entitled of any units. And now under the new law, January 1, it's double what it was before. I think one of them was market conditions and what product type is the best fit for Belvedere. A lot of it had to do with community feedback. And one of the #1 things that was said was, can you please build single family along the lagoon? Continue the development pattern along the lagoon. So once you use all of that space, you're only left with the interior of the site because it's very low density product on the lagoon. And by the way, there's a subdivision map attached to this. So this is just lots along the lagoon, exactly like all the others. The only place the higher density product goes is upland. That's on the site plan.
Okay, thank you.
Jane, do you have further questions?
I was a little confused when you said that our new housing element meant that all housing is ministerial going forward. Is that what you said?
Definitely not all housing.
Oh, okay.
The housing element law, when you don't meet the deadline for getting your housing element certified on time, and when you are required to rezone sites, which Belvedere eventually pivoted to after the initial go around, those sites are required to be rezoned for by right approvals. When you are, so we've been talking about CEQA exemptions, which are their statutory and categorical, but you don't even get to the exemption question if your project is ministerial, i.e. by right. So if someone comes in under your new zoning and they want to do housing on one of the sites that got rezoned with your new higher density site, and they conform to your objective standards or get waivers or concessions therefrom, it's a ministerial permit. There's no environmental review. I heard misstatements about that during, the earlier process, and folks may disagree with me, but I'm doing by right development all over Marin, and the investors that are starting to come to Marin, they only want to do that because the discretionary stuff looks a lot like this.
But just to be clear to everybody here, we're talking solely about the rezoned areas, not all zones in Belvedere.
Absolutely.
Okay.
Absolutely.
Can I ask one additional question? So we've definitely heard from residents stories of other projects that Thompson Dorfman has developed that have somehow not been delivered appropriately or with deficiencies. And so I guess my question to you is, has there been any cases where Thompson Dorfman has faced penalties or anything else for poor execution of a project?
I'll let Thompson Dorfman answer that.
No.
I don't think I have any follow-up. We did, as a city, do some due diligence ourselves, and we reached the same conclusion. But I wanted to know, I'm assuming that's a legal statement that you've made there and that there's no penalties or anything else you've ever received?
We've never had a project go into default. We've never had an issue with any of the agencies on our performance. All the projects have been executed in accordance with the plans and specs and the conditions of approval.
Okay, thank you.
Just one quick question. Mr. Hurd, you mentioned that the higher density is upland in the projects. I certainly understand that with the duplexes and the single family homes along the lagoon. And considering that we're looking at the potential impact on water quality in that location, I assume that whether, and I'm not making a statement whether it does or doesn't, that those properties would conform to the same development standards required by the underlying zones there. Because I don't believe they currently do, meaning the R2 doesn't have specific FAR limitations or guidelines, but if they are designated as single-family homes, they need to apply to the underlying R1 zone, which I'm mentioning it because it would arguably then be no different than a single-family development in the R1L zone.
I can state that your R2 zoning code says if you're doing an R1L use, you need to follow those standards.
Okay, perfect. Thank you. Any more questions before we move on? Thank you. We'll now turn the podium over to arguments against the appeal, and they'll have 15 minutes for that.
Good evening, Mr. Mayor, members of the council. My name is Mark Wolf, here for Brig. I'm going to take 10 minutes and then turn it over to the attorney for BLPOA, if that's okay. So Madam Clerk, if you could give me 10 minutes on the clock. like to begin very quickly with a point of order, and that's to address the question that's come up procedurally as to whether you can deliberate and act on the first criterion of the categorical exemption for infill, which is consistency with the general plan and zoning. I agree that you have de novo review power here, and you by no means have to defer to anything the planning commission did. However, if you look at section 20.04.070 of your municipal code, which governs appeals to the city council of planning commission actions, number 1 says that appeals shall set forth the alleged inconsistency or nonconformity with procedures or criteria set forth in this chapter, number 1, and then says the council may affirm, reverse, remand, or modify the decision of the planning commission. So the planning commission didn't act on this. They didn't make a decision with regard to the first criteria. As you know, the appeal that came in didn't appeal any aspect. It didn't mention it. And Mr. Hurd's well-written brief didn't address the question at all. We weren't prepared to address it tonight. It sounds from Councilmember Cooper's statements that although it was attached, the planning commission staff report was attached, you have not been briefed on this issue. So we would ask that you not deliberate, take action on that issue tonight, because I don't think it would be appropriate for you to do so. Slides. I only have 3 or 4, thankfully. So that's the cover slide. I'm here on behalf of Brig, as I said. Next slide. I do really want to focus on the issue of urban use. And there's a couple of things here. It's a lot of information on the slide. I apologize for that. But we have several different sources, not just of law, but of policy and common sense that can guide us in determining whether the lagoon is or is not an urban use for purposes of qualifying for this exemption. Correctly, it is correct that the exemption itself doesn't define urban use, nor does it define the term substantially surrounded. I would point out a couple of things. The exemption appears in a regulation that was promulgated by the State Resources Agency. It doesn't appear in the CEQA statute itself. So in other words, the legislature didn't put the verbiage of this exemption into anything. It was a regulatory agency that did so. So if we are to interpret that phrase, I think most courts would agree that first and foremost, we look at the statute that originated the concept, i.e. CEQA, to see if that term is used anywhere else in a related or similar context. And here it absolutely has, in this provision of CEQA that governs infill housing. I submit to you that no court would disregard this definition that has been provided in the CEQA statute. Qualified urban use means residential, commercial, public, institutional, transit, transportation, et cetera, et cetera, et cetera. It is completely proper to look at that definition in your deliberations tonight. I would also point out that the Bankers Hill case didn't define urban use either. It simply held that Balboa Park, because it was fully landscaped, had restaurants, museums, was the quintessential urban use and therefore qualified for the exemption. But that case did not provide an actual definition of the term. And again, you have discretion to interpret that yourself in the context of this lagoon within your city. Let's move to the Belvedere General Plan. I would point out that if you look at the land use map, it's designated open space. I've never heard of open space that's urban. It also clarifies that it provides habitat for a variety of migratory bird species, and there is a policy in your general plan calling for the management using the most effective environmentally friendly methods available, considering that the waters empty into Richardson Bay. The Corps of Engineers, I don't think there's any dispute at this point that it is not a wetland per se, but it is a jurisdictional water. It is a water of the United States that is hydrologically connected to San Francisco Bay and therefore under the permitting jurisdiction of the Army Corps and also the Regional Water Board. I would point out further that Ascent didn't take a position on this, as far as I could tell. If you look at their report attached to the Planning Commission staff report, they pointed out both sides of the case, similar to the way Ms. Couch did earlier this evening, but they did specifically say Belvedere Lagoon is not a public facility, includes none of the listed uses, and so is not a qualified urban use. And then finally, with respect to the Bankers Hill case, as I said, they didn't define the term. They just said that Balboa Park, because it's landscape, surrounded by a densely populated area and containing urban amenities such as museums, theaters, and restaurants, was an urban use. And we think that's patently distinguishable from the Belvedere Lagoon. Next slide, please. That's just a picture. We showed that to the Planning Commission. You've already seen that before. I don't need to dwell on it. That was the lagoon in its pre-engineered state. Now, you will hear more tonight, I understand, about the history of engineering of this landscape. It was a natural lagoon. It was silted over, it was dredged, it was filled, it was engineered by humans into the state that it is currently. I think that's a bit of a red herring, because the fact that it's been engineered by humans is not a determining or dispositive factor on the question whether it's an urban use or not. I was trying to come up with an analogy, and the best I could come up with is a vineyard. Think about a vineyard that you see when you're driving up to Napa, Sonoma. These are some of the most heavily human engineered landscapes in the state. They've been deforested, planted with vines. They often have irrigation channels running underneath them. They're sprayed with pesticides. They are as engineered, if not more so, than this lagoon. I don't think anyone would say that these vineyards are urban uses, because they're not. Finally, my last point, actually, if you could go to one more slide. BLPOA's lawyer is going to get more into the details of the unusual circumstances. I would just point one thing out. We had a geotechnical expert, Dr. Karp, look at this. He's been around for decades. He's consulted most recently with the city of San Francisco on the settling of that infamous Millennium Tower. He came up with the engineering solution to fix that. He pointed out that the issue really is the fact that you have a long, narrow apartment building on soils that are dredge or fill material and bay mud susceptible to liquefaction and settling. And he said, by virtue of that long, narrow configuration, the proneness to uneven settling is real, and it will require engineered solutions. We don't know what those are yet, because they haven't done the necessary studies to this point. They've only done a preliminary geotechnical report. It may be that you can engineer those foundations, no big deal, but it may be that you have to do more, and that those would have corresponding impacts on things like noise and vibrations in the area. And I would just point out, I don't want to put words in the building official's mouth, but this is from an email he sent to the planning department in that paragraph below. I'm just pointing out here that everyone seems to agree that there is a need for further study because of uncertainty about what's going on subsurface. We don't know what the soil composition is. We don't really know how deep the bulkheads are going to have to get driven. We don't really know what's going to happen potentially from demolition and construction of all of these units along this large lagoon frontage. We just don't know. Yes, they will require permits from the Army Corps and the regional board. When that happens outside of the CEQA context, reports get sent, the staff members look at them. There's usually a lot of interaction back and forth by email. And eventually, if that staff member, and maybe that staff member's boss, are themselves satisfied that the study is adequate and that the mitigation measures are going to be functional, they get the permit. And that's great. But keep one thing in mind, is that is done outside the public purview. If it's within the CEQA context, if there is an initial study that is released for public comment, then all of us get to review that study and we get to comment on it. Not only that, but the regional board staff and the Army Corps staff, they have to respond in writing on their letterhead, knowing that everyone else is watching what they do. We all get to participate in that decision-making process. If any member of the public here sees a problem with the geotechnical report or a water quality report or something that was submitted with the permit application, they can put that in writing to the city, and the city has a legal obligation to respond to that, to think about it in writing. So if there's something that one of the agency staff members missed, or if one of the applicant's consultants might have missed or didn't consider, and someone in the member of the public or someone from BLPOA spots it and brings it to the city's attention, you have to consider it. If you find the project exempt, none of that has to happen, because there is no formal opportunity for public comment. Yes, people can review it and send in concerns, but more importantly, there is no legal obligation to respond to public or other agency comments in writing. So there's a real consequence of finding the project exempt. And we would submit that for all these reasons, first and foremost, the Belvedere Lagoon is not an urban use. That's a dispositive finding. If you find that it's not urban, you don't need to get to the other ones. It's not exempt. I see my time is up. I'll happy to take any questions or or ask BLPOA's where to come up for the remaining 5 minutes.
Why don't we hold off on the questions till this second presentation? Okay. Would you rather us now? I think I'd rather go through the full 15 minutes and then ask questions if that's okay.
Good evening. Can you hear me?
Yes, we can.
Terrific. Thank you. Good evening. My name is Wendy Manley. I'm an attorney with Fenimore Wendell out of Oakland. I'm appearing tonight on behalf of the Belvedere Lagoon Property Owners Association. I've been their counsel for several years, advising on water quality responsibilities and annual reporting to the state of California. So I wanted to be clear that I was hired well before this project was ever submitted. I was not hired for the purpose of commenting on this project. I submitted letters in July of 2023 and then yesterday that described the potential water quality impacts that the BLPOA is concerned about impacting the lagoon. I'm not going to repeat that here. You have that information. I wanted to be here to address any questions you might have, confirm BLPOA's support for the comments and analysis that Brig has presented with respect to the CEQA exemption and exception, and also to emphasize that the potential water quality impacts do have some potential to have serious consequences for the lagoon and BLPOA. The concern that's focused on water quality is that during and post-construction, there could be issues of water quality primarily from sediment along the shoreline. We feel that this has not been addressed in the sufficient detail at this time. We acknowledge that there are permits that would be needed from the Regional Water Board. In particular, the construction general permit really does not address issues of slumping of sediment into the lagoon from construction activities and vibration that would occur during construction and demolition. And so that wouldn't be addressed unless there were a permit that applied to the bulkhead work and the dock construction. If that's going to be put off for some period of time, then there's potentially a gap here in the coverage. The scope of the Regional Water Board's permit here is a little bit unclear. There's a general permit that could possibly apply, but again, we don't have enough information on, what the bulkhead design and reconstruction is going to consist of. The applicant has indicated that that will be decided later, whether it's going to be replacement or repair or just shoring it up and for what lengths. And it's also not clear when that construction would be done in the phasing of the project. And those have potentially important impacts on the lagoon and on the BLPOA. Just to note a couple of things, the lagoon is 68 acres. It's a sizable lagoon. It provides wildlife habitat. It is carefully managed. It is not dredged every year. And herbicide application is pursuant to a state permit, and that doesn't even occur every year. It's done very sparingly. So it's managed for water quality, and it's managed to maintain flood control capacity to protect the surrounding area. So it actually serves much of the area beyond the local homes that are right along the margin. We feel that the total circumstances that define and characterize this project in this location are fairly are unusual circumstances, even though individually each factor is not unique. There's really no requirement that all those factors be unique. The project is lengthy for the size of the lagoon. It is separated from the lagoon by a failing bulkhead. We've heard a lot about that already, but that is a really critical aspect of the project. If we could get the bulkhead replaced early on, that would provide a lot of protection to the lagoon. So we haven't got enough information. I think the consensus is that we need to have a better understanding of what's going to be done, what's planned, and what the sequencing is before we can be comfortable in the way that this will protect the lagoon. I will close at that. Thank you.
Thank you very much. Why don't we bring it back for questions for both Mr. Wolf and Mrs. Manley? Sally, would you like to go first? No? Jim?
Mr. Wolf, while you're coming up, let me also thank you very much for all of your tireless work. You have submitted a lot of materials. I found them very helpful in trying to join the issues. Thank you for your best efforts to help us do that. I wanted to begin with a question of whether we tonight should be considering criteria number 1 in the exemption. And I appreciate the point that you didn't brief this time around, but the November 27 notice of appeal, the first line of that is that this project is exempt from CEQA under the infill exemption. That's a catch-all, right? I mean, that kind of puts everything at issue, right? I'm asking because I was trying to figure out what's at issue on this appeal. What do we have to deal with and what can I ignore? But line number 1 kind of puts everything out there, doesn't it?
Line number 1 puts everything out there, but I think if you read it in context, they appeal the determination that the Planning Commission made that the project did not qualify for the infill exemption because it found that the Belvedere Lagoon was not an urban use and because of potential significant impacts to water quality and unusual circumstance. I believe those were the 3 grounds of the appeal, notwithstanding the catch-all at the top.
And your letter of November 13 did actually address criteria number 1, right? Okay.
We absolutely addressed it with the Planning Commission. The issue is the Planning Commission didn't address it.
Okay. All right. I think I understand where you're going.
Jim, real quick, your letter just last week also addressed it over a page and a half. The first subtopic A, project is not consistent with applicable zoning and designated regulations.
You're correct. We did that belt and suspenders just as a safety in case the city staff or the appellant brought it up tonight, but that hasn't happened.
Okay.
In substance.
So forgive me also, because when you talked about, I'm changing topics now, going to the qualified urban use definition, and in your slide, whatever section of the PRC you were quoting was covered up by the clock and something else. So can you tell me what that section was? Well, actually, let me do this. This is the one you've been citing in your letters, which is 21159.25.
In the staff report and by assent as well.
Okay, all right. And you heard, I think, the questions from Council Member Wilkinson earlier that 2019 statute begins with the language. The definitions here apply only to this section, right?
Doesn't it say for purposes of this section, the following definitions apply?
I think it does say that,
Which I would submit is not the same thing as saying it only applies to this section and cannot be used to provide guidance for the interpretation of similar terms everywhere else.
Okay. And so when you go farther down in that section with subdivision 25, you eventually get to subdivision 3, which says this section applies to projects in unincorporated county, right?
Again,
that's what it says.
It does say that.
Yeah.
The point I was making is that definition in that section, even though it obviously is not geared towards the class 32 infill exemption, is it a source of guidance for interpretation of the term urban use in this context? And we would submit that it is, because it appears in the CEQA statute, and the fact that it doesn't appear anywhere else, it doesn't appear in the regulation itself, and it doesn't appear, quite candidly, in Bankers Hill. And so where do we go to get help to see what did the legislature intend, or what did the regulatory agencies intend? What is an urban use? And we have this definition in the same statute. Yes, it was enacted in a different context, but it's awfully similar, urban use versus qualified urban use. And to disregard it as not having any relevance, I think would be a legal error, quite frankly.
Okay. And so qualified urban use was actually first defined in the PRC in 2003, right? Under a different section.
I don't know.
Okay. Except that is true. So it was qualified urban use was defined in section 2106 1.3. And that happened 3 years before Bankers Hill issued in 2006. So the Bankers Hill court had that statutory definition of qualified urban use and doesn't reference it at all. You're aware of that?
I am aware that they don't reference it.
Okay.
We can only speculate as to why. I would submit that most likely it was the parties didn't brief that issue. But by the same token, they specifically did not say, we're looking at this issue and we're not going to apply it. They could have done that too.
Okay. And class 32 is not a statutory exemption. It's a regulatory exemption, categorical. And those regs, the guidelines, as they're called in CEQA land, can be amended, right? They can be updated and changed and added to, right?
Sure.
Okay, so this definition of qualified urban use shows up in 2003 in the statutes, and 4 years later, regulations are issued, promulgated to give life to this statutory exemption that doesn't apply here. So my question to you is, can you help us understand why a court would be moved to look at qualified urban uses where in the 20 years since that phrase was first defined, the class 32 exemption, that regulation hasn't been updated at all to adopt that language?
I can't speculate as to why, if your question is why would a court look at it?
Why would a court look at it if in the 20 years since it became part of an irrelevant statute, that language wasn't imported into the regulation that we're dealing with tonight?
Why it wasn't incorporated into the regulation, I can't speak to that. I can say that courts interpreting statutes or regulations are guided by what are called the canons of statutory interpretation, and they actually go down a hierarchy. They start with the plain language. Is the language so clear that we don't need to interpret it or look to extrinsic sources for interpretation? Obviously, that's not the case here, because we don't know what urban use is and we're still fighting about it. From there, they go to other parts of the same statute. I can't provide you a site. I'd be happy to. Tomorrow morning, I can email it. But they absolutely look at the entire statutory scheme. They look to see if the legislature has used a similar or the same term elsewhere in the same statutory framework. And again, I'm not saying that they're absolutely bound by that and they throw up their hands, but they will absolutely look at that as relevant and be guided by it to some extent. And I'm just saying that you can as well.
Okay, that's helpful. And when we do that, if we were to apply these canons of interpretation, or if a court were to do that, wouldn't it consider what the word qualified means and ask itself whether the presence of that word qualified limits or in some ways modifies the words that follow, which is urban uses?
They very well could.
Yeah. And qualified means in part having complied with specific requirements or conditions, right? Being eligible, right? It's a subset of that which follows it, right?
Well, we could also interpret qualified urban uses as that subset of the listed uses, whether it was public facilities, commercial facilities that have gone through that qualification process, but that's still, that term qualified modifies a fixed set of things that don't include 68-acre lagoons that are hydrologically connected to the bay.
Right. So qualified use, urban use enumerates specific categories, right? And urban use is just not defined. So the question is urban use confined to those 5 categories of qualified urban use, or is urban use broader in some way? That's kind of the question, right?
That is the question. And as Ms. Couch put in her presentation correctly, you've got arguments on both sides. We think the arguments for finding the lagoon not to be urban, based on looking not just at that definition in the Public Resources Code, but everything else that we put up on the slide, that evidence outweighs the evidence supporting a finding that it is an urban use, is our position.
Okay, that's helpful. Thank you. Let me ask you, follow up on a question that Mr. Hurd, or a point that Mr. Hurd raised. He was sticking with qualified urban use, I think, for discussions purposes. And it begins with residential. That's the first one. And then there's this public institutional use. And you heard him talk about that. And he argued that the lagoon is, even if you were defining this, even if qualified urban use applied, you could say that the lagoon is one of those because it serves a public institutional use as a stormwater catch basin. And can you respond to that? Give me your reaction to that, please.
I'm not aware of a binding definition of public institution elsewhere. Certainly, it's not in that section of CEQA, unless I'm wrong. But I would think a public institution is like a university or a hospital, or it's not I mean, a public fixture or a public, I don't know, is a sewage system a public institution? I wouldn't call it that.
Although some public institutions are sewer systems, maybe it goes the other way, if that's your point.
Touché.
One last question. I don't want to dominate the time here. There's a series of points that are made in the assent memo and that show up in the staff reports, both staff reports, including tonight's. And it is, in tonight's report is on page 11, and it says that many of the site conditions that are present at this proposed site, bay mud, floodplain, et cetera, are environmental effects on the project and are not environmental impacts under CEQA. And it cites Cal Building Industries, the Supreme Court, California Supreme Court case. Can you tell me whether you agree with that or if there's something more I need to know about that?
So I actually had that on my slide and then my time ran out before I got to it. So it is a correct statement that CEQA does not require analysis of the environment's impact on a project. It requires analysis of project's impact on the environment. Here, the issue isn't so, from our perspective, about the soils. It's not that the project is going to hurt the soils. The issue is, by virtue of the soils, and once again, we don't really know what's going on under there. There is a reasonable possibility, a fair argument can be made that it will require engineered solutions, engineered foundations. This is what Dr. Cart put in his correspondence, which you've seen. And doing that will generate vibrations, potentially serious vibrations, as well as noise impacts, both of which are considered environmental impacts for purposes of CEQA. So it is the effect essentially of that aspect of the construction that could have significant impacts on the environment.
Thank you. That's very helpful.
Jane, do you want to go or do you have questions? No, Sally?
Yeah, I just want to go back to the urban use question. And so as Jim already mentioned, the qualified urban use was already in existence before the Bankers Hill case was determined. And even with that, they specifically said, we have not located or been directed to any authority interpreting the phrase substantially surrounded by urban use. So that seems pretty clear to me. And then they go on, therefore, to define urban use as the term urban is not fixed, objective, or easily ascertainable, but it has been defined as relating to, characteristic of, or taking place in a city, constituted or including a center of a city, of, relating to, or concerned with an urban and densely populated area. And it goes on. So they then refer back to the Friends of Mammoth case, where that seems to be the first time that they have ever really talked about urban. And again, there they say the term urban refers more to the location and varying characteristics of a use rather than the type of use, i.e. it's not what, but it's where. And they then go on to because this case is specifically looking at a development outside of a city, including a golf course, they specifically talk about this golf course in that this golf course that's actually being considered is outside of town, mountain style course, significant amounts of natural preserved forest land and water features interspersed throughout the course. So in this determination, it says this golf course is not therefore an urban use. And so the characteristics of this golf course can hardly be related to or characteristic of a city or a densely populated area, and therefore we conclude that it's not an urban use. But by contrast, using that golf course definition, a golf course in the middle of Los Angeles would be an urban use, correct?
I would tend to agree, yes.
So using the same comparison, if I think about Phoenix Lake outside of Ross, which is a water area, to me, that would not qualify as urban use because it's outside of the town. There's no utilities there. There's no housing around the outside of it. There's no roads to get there. It's a dirt path. That's not an urban use. To me, that seems very different from a lagoon in the middle, smack middle of the city that is entirely surrounded by houses, that is used for recreation, and that is managed by a property owners association. So I'm just really struggling with this idea that I can see why there can be examples where lagoons might not be urban use based on their locale. But in this case, it's right in the middle of a city. So I'm just struggling. Can you help me understand why that under all of these definitions and descriptions established under law, under case law, why this would not qualify as an urban use?
Responding, I think, to your first point, which was you quoted from the Bankers Hill case, and you said, you pointed out what a point I was making or trying to make a little bit earlier, which was they said, we have not been directed to another definition. What that means is the parties didn't bring it up in their briefs. I wish appellate judges knew every aspect of the law at all times, but the fact is they don't. I would suspect that no one briefed this to them. So I personally think we cannot read anything into the Bankers Hill court's non-citation to the term qualified urban use. I don't think it dispenses with anything one way or the other. So I just want to say that clearly. They didn't address it. And as any court will tell you, if it's not addressed, it's not dispositive, it's not binding. So we can't say, well, qualified urban use can provide no source of guidance to us tonight. It has no relevance to our discussion tonight because it was not cited in the Bankers Hill case. To answer the specific question, agreed, urban use depends on context. Once again, there is no fixed definition. And so a golf course in the middle of LA, urban. Golf course further out, maybe not. Phoenix Lake, I could see arguments both ways. I mean, it's a water supply, right, for much of Marin. It's close to a city. I could see someone making that argument. The question is, would that argument be struck down by a court? Is not based on substantial evidence. It would depend on the evidence that was brought. What we're saying here is that if you look at the totality of the circumstances, habitat, I mean, a golf course, I don't know, maybe it provides some habitat for something, but jurisdictional water of the Army Corps of the United States, subject to court jurisdiction, subject to regional board jurisdiction, provides habitat designated in your general plan as open space. These are all items on the scale. I mean, ultimately, that's what we're doing is we're looking at the evidence for, the evidence against, just as was put up on the slide. Your decision, if it's based on findings, I believe will be granted deference by a court if it's based on substantial evidence. We believe there is abundant substantial evidence to support a finding that the Belvedere Lagoon is not an urban use. I'm not here to tell you that there is zero evidence that it is, but the bulk of the evidence, in our view, is that it is not. And we're asking you to use your discretion to balance the conflicting evidence and make that finding tonight. And again, the consequence of that is we get more thorough, more open, more publicly available environmental study. Much of the study has actually been done, as you've heard, but now it gets put out for public review and public comment. And it's all done out in the open. That's what you get.
So just to follow up on that, so as you just said, my understanding is that we've pretty much done all of the studies required for an initial study.
Some of them, not all of them.
Okay, so we've done a lot of studies already. And if this went to an initial study and then it went to a full EIR.
Or a negative declaration.
Or a negative declaration, but your hope is that not only would there be input from lay members of the public, that we'd have the relevant permitting agencies and everybody else comment during that process, and somehow that would provide more clarity.
Yes.
So using the example of our Protect Belvedere project, which we did a full EIR for, 2 of the 3 main agencies didn't comment during that process. They didn't bother because it was a small enough project and they would be, again, engaged during the permitting process, that they didn't take the time during a full EIR to comment on the Protect Belvedere project. And that was which 2 agencies? I don't remember, but which 2 agencies did not respond?
Tell you who did respond, and it was Fish and Wildlife, and no other agencies responded. So Regional Water Quality and Army Corps did not respond.
So nobody responded. And so my question to you is, what do you think an EIR get? I understand that it allows members of the public to submit tens of thousands of comments if they choose to do that. I'm just struggling to understand what additional information it could give residents in terms of a surety, given that we don't have any guarantees whatsoever that any of the permitting agencies would even respond to a full EIR, let alone an initial study.
Well, first, I don't think we can or should try to presume that because some agencies didn't respond to one EIR, that they wouldn't respond to another one.
I mean,
I don't think we can.
that's a reach. This was a major public investment project in a seismic upgrade, and this is a tiny infill project.
So I can't speak to why they didn't. I'm just saying, I don't think we can presume that because they didn't in this one case, that therefore they're not going to in another case, and particularly in a project that has generated this much public interest, to put it lightly, that they wouldn't, particularly if they were encouraged to do so by members of the public. What you get from a CEQA process, and let me also be clear that obviously, I think the preference of many members of the community would be to see a full EIR, but that's not what CEQA requires. CEQA requires, if you find the project is not exempt, the next step, as we've heard, is an initial study. The initial study will look at air quality, water quality, geotechnical issues, but it will also look at, and biological resource, but we'll look at noise, we'll look at traffic, we'll look at energy use, we'll look at utilities, impacts on public services. There's a whole gamut of resource categories that must be evaluated in an initial study that is not part of the class 32 exemption list, which is just air, water, biology, and noise and traffic. That's what, so number one, you get that. If, as a result of that initial study, which the public gets to comment on, and to proceed to that aspect of your question, what you get is the public has an opportunity to review this. If they want, they can hire their own peer reviewers, other qualified experts to say, gosh, this study seems deficient in the following respects. We've gone out and we've looked at the bulkheads. Again, this is all hypothetical. And here's what you missed. Unlike now, where people have said that, but nothing's happened in response because there's no duty on the city's part to respond to any of those comments. If you're an initial study, if you're in that process, it goes out for 20, if not 30 days for public review, and there becomes a mandatory duty on the city's part to respond in writing to everything, and they have to consider what the public has said. And so if another expert or layperson says, you didn't look at this, you missed that, you're wrong in this assumption, the city can't just ignore it, it has to come back. Second, if it's an initial study open for a public comment period, the responsible resource agencies, if they don't respond at all, again, I don't know the context for the other EIR, but as a member of the public, I would say that's a dereliction of their responsibilities. I mean, they're supposed to be looking at these things and they're supposed to be reviewing them, putting in comments. Kudos to Fish and Game for doing that. But I think in this context, members of the public would be completely free to send comments to them saying, look, you need to look at this. We see some issues here and we encourage you to put comments into the, and I would hope that they would respond and do so. So you get a lot. It's not just the fact that studies are produced. It's the fact that they are produced and they are made available. They're done in the sunlight, out in the open, in a public process that requires actual consideration and response to comments. The legal standard, by the way, under CEQA is the agency has a duty to respond to public comments with, quote, good faith, reasoned analysis. And that's something that we like to see agencies do in response to public comments, as opposed to simply saying, thank you very much, we received your email, and nothing happens.
Sally, can I follow up on that real quick? Absolutely understand and thoroughly see the benefit of the sunshine as you described and the transparent process associated with that and what the community gets and the preferences of a majority, certainly of the people who are here tonight. But it's been made pretty clear that this decision tonight is based on 5 sets of criteria, and it can be disqualified by 5 different exceptions. And it's even been narrowly defined by you yourself to just 3 points that we're looking at this appeal and subsequent exemption. How is what the community gets, the benefit of it, a factor that goes into determining these exemptions?
It's a policy consideration to keep in mind if in your mind it's a close call. Again, as you've been told, if you base your finding one way or the other on substantial evidence, it would probably be upheld in court. And so if you're going either way, gosh, I see the arguments for, I see the arguments against. Instead of flipping a coin, think, what does the public get from one decision versus the other? So I think it's a policy basis for resolving any uncertainty you might have in weighing the evidence.
I just have to say that, I mean, we've heard from a number of these, a number of letters, and we've read every single letter, and a strong sentiment has been to disregard the larger plan that the applicant has put on the table as a consequence of having to do a full initial study and potentially an environmental report, should that be found not exempt. And that's not relevant here either, as far as what the criteria and the conditions were asked to look at this. I don't see how that consideration should be a factor in these exemptions if we're asked not to look at the broader project that might be a consequence of not choosing this exemption. Do you see that parallel? It's hard to say. We certainly want the transparency, we certainly want the openness, but it's not a factor to look at. We certainly don't want a bigger project necessarily, or maybe we do want a bigger project, but that shouldn't be a consideration either. They seem to be parallel to me, and which brings me back to, I think we need to look at specifically what are the criteria that is being asked of this for the exemption, and are there any exceptions that would invalidate the exemption itself?
I agree. I concur. Clearly, whether the lagoon is an urban use or not, that's one of the criteria. Whether the applicant has trying to come up with a tactful verb, suggested the possibility of a much larger project if the council denies the exemption is not one of the criteria. You're correct. So we're dealing with an actual criteria here.
But similarly, the larger transparency benefit to the community, that's not a criteria either. I see it. It's a benefit. I get that. But that's not a criteria either.
Right. But the consequence of finding a project is exempt is that it does not undergo formal environmental review under CEQA with the public comment period and everything else that's provided. That is the consequence. And so given that, you don't have a binding definition of urban use because you don't have a binding list of what constitutes unusual circumstances. What you have is discretion. What you have is the ability to look at this evidence yourself and reach the conclusion that you believe A, is legally defensible. It has to be. You can't break the law here, but is in the best interest of the city and your constituents. You absolutely have the discretion and the leeway to take that into consideration, I believe, within the confines of looking at the 5 criteria. The extrinsic concerns about what could happen, I would agree with you, are not properly, should not be part of your deliberation tonight.
Thank you.
Can I go back to the first criteria? Because my understanding is that is, Jim, do you want to take this rather than me, or?
You mean asking the questions about the government code?
You might.
Sure. You know, the question, Mr. Wolf, I think is, having read your November letter and your January letter, where you briefed these issues, and you heard some of the colloquy, I think, at the outset of this meeting, there are 2 government code sections, and I would like to get your reaction to it. One is 65589.5J3, which basically says the receipt of a density bonus is not a valid basis on which to find that a housing development is not in compliance or not in conformity. All right. So just because you got a density bonus concession doesn't mean you're not in compliance. And the end of that section makes it clear that it's referring to concessions as well. In this case, it would be a concession to avoid the R2 prohibition on an apartment building. And there's another government code section 65915K, which defines concessions, and it's as broad as it could be.
But not as including a use restriction, respectfully.
It doesn't enumerate that, but it refers to a reduction in site development standards or a modification of zoning code requirements or other regulatory incentives or concessions proposed by the developer that result in identifiable and actual cost reductions to provide for affordable housing costs. And just to pick up your other point, in the previous code section that I referred to, it distinguishes between waivers to development standards and concessions. And so there's nothing in here, as I read those 2, that says that waivers can't apply to a R2 prohibition on apartment buildings. And so with that, can you answer?
So it looks like we're going here. Okay. I would just repeat, just for the record, that under your municipal code and based on what was defined in the appeal letter in the first instance and the appellate brief, I don't believe this is a proper topic tonight. I just want to say that for the record. Having said that, and without waiving that objection, as we've argued in a lot of the written material that I've submitted a lot, as you said at the beginning, and I apologize for the prolix nature of some of my correspondence there, but we've briefed that at length. And if you look at the cases that we cited, and unfortunately I don't have my letter in front of me tonight, we conclude, and we believe the law supports our conclusion, that a land use restriction can't be waived, or the enforcement of it can't be waived under the guise of a concession of the state density bonus law. The state doesn't say that it can. And if you look at the case, the Walmart case that gets cited, they clearly were talking about things like height limits, setback requirements, density, other physical aspects of the building, not a restriction on land use. And I'm quite confident in saying that there is no case that says that a land use restriction can be forfeited, or enforcement of it can be forfeited by a city as a concession under the state density.
Thank you. And just for the avoidance of doubt, I wasn't criticizing you for the volume of your input. I was actually genuinely thanking you for it. It is very helpful. So one last point, though, if we don't take that issue up tonight, criteria number 1, in other words, if this council doesn't make any findings relating to criteria number 1, when and how would we do that?
So 3 scenarios, I guess. Scenario 1 would be if you agree that the lagoon is not an urban use, analysis stops. We're done. It doesn't qualify for the exemption. Scenario 2, you find that it is an urban use, Then you proceed to, what about substantial evidence of significant water quality issues? If you find that there's substantial evidence supporting potential finding of substantial water quality issues, stop again. It's not exempt. Third scenario, if I said two, I apologize. You find that all of those criteria are met, but then you look at the unusual circumstances question. If you find that the demolition and construction this close to the lagoon and the extent of the bulkheads that need to be either replaced or repaired constitutes an unusual circumstance, giving rise to potential significant impacts on water quality, you stop there. Project doesn't apply. If you don't get any of those, then I think you go back. You presumably would then grant the appeal. It goes back to the Planning Commission to consider, in the larger context, this consistency with the general plan, the concession, the waiver issue. Again, I'm not your city attorney or your outside counsel. I can't give you advice, but it would seem to me those two issues are so closely related that they would be considered together.
Okay.
And you would have to determine, does the project get to evade the R2 apartment restriction? And if it does, then I'm not going to say definitively that deals with criteria 1, but it's obviously going to go some distance in that direction.
All right. That's very helpful. But you would also agree, I expect, that if this council made a finding on criteria number 1 tonight, we would rely on whatever we contended was substantial evidence in the record, including the underlying Planning Commission record, and it would be reviewed by a court on that basis. You agree with that?
It would, within the narrow confines of determining whether the CEQA exemption was properly found. On the separate question, whether it qualifies under the state bonus law, I think that was the concern raised by Mayor Mark, which is, if you make this finding tonight on the CEQA question, are your hands tied?
Yeah.
And that's another reason, in addition to the ones that I presented, as to why I don't think you should reach that issue tonight.
That's helpful. Thank you very much.
Any further questions?
I do have some questions, and this is in relation to the criteria 1, which I do believe we're considering tonight. From what I've understood in terms of the Woolmer ruling, which seemed to say that you, to quote, "There is no support for the misguided assertion that the city's waiver of zoning standards as mandated by density bonus law precludes the project from qualifying for the exemption." So we are considering it tonight, and that's proper to do that. And so going back to the definitions within the density bonus law, just to sort of restate them, it says, for the purposes of this chapter, concessions or incentives mean any of the following: a reduction in site development standards, or a modification of zoning code requirements or architectural design standards. So modification of zoning code requirements. Now, your contention is that a prohibited use isn't part of the zoning code, correct?
No, that's not my assertion. My assertion is, if you look at that definition, if you interpret that as a set of things that can be waived or conceded, they all pertain to physical design characteristics or placement on a site or lot size, physical aspects of the construction that would otherwise render an affordable development project infeasible, right? Again, keep in mind, the whole point of this is to prevent an otherwise affordable, feasibly financed affordable housing project from not being built because adherence to these physical requirements is going to make it too expensive. That's the whole point of this, and we shouldn't lose sight of that. There has to be actual demonstrated cost reductions, which is a whole other point that we need to talk about. In order to, again, the applicant doesn't have to prove it, but the city still gets to inquire and ask for evidence to support it. That's a separate question, excuse me. But to answer your question, all of those, so when they say zoning requirements, it's in the context of design standards, development standards, again, all physical things, architectural, whatever that phrase was, I'm sorry. But
how do you know that?
Because that's a reasonable interpretation of that. There's nothing in the state density bonus law that says you have to throw out your existing land use restrictions. It says you have to disregard the physical restrictions that make an affordable housing project too expensive to build.
So you're telling us how to interpret what modification of zoning code standard requirement means. You're telling us that your interpretation is that that excludes
Mhm.
prohibitions. But I just want to go directly to the City of Belvedere's code, and specifically the chapter in our code on the R2 zone, which is the area that we're talking about here. And so, as I understand it, zoning describes your land use in terms of residential, commercial, etc. It describes density, it describes building size, setbacks, etc., and building form. And so when you look within this chapter, it has permitted uses is the first element, uses permitted under a permit, prohibited uses, development standards, and design review standards. So very clearly within our zoning, actually within our code under our R2 zone, is prohibited uses. So how can you say that that's not part of a zoning code requirement? I'm just lost.
I'm saying that if you read the section of the density bonus law that you quoted, the string of things that can be waived or conceded all pertain to physical design standards. And the term zoning requirements read in the context of that list, we interpret as saying other zoning related things, whether it's, I don't know, paint color, roof heights, angles, anything physical that governs construction and imposes costs on construction of structures. To read it as including a use prohibition, I think is unreasonable. It's to basically say you can grant a density bonus of any kind that completely disregards what you've decided is not appropriate and therefore not permissible within a particular area of your city that you've zoned for. I don't believe that's a reasonable interpretation of that phrase.
But the way that that section goes on is that you're right, it describes some of those possible examples, but it says it's not limited to those examples. It says, but not limited to, for example, a reduction in setback, square footage, etc. So it doesn't actually define the limitations of that. It strikes me that it's trying to be as broad as possible modification of zoning code, and within our own zoning code under the R2, one of the elements is prohibited uses. So I think what you're saying is, again, like so much of this, it's open to our interpretation of what this means. There isn't any clear definition, but this is your definition that you want to present to us.
Yes, and I guess what I would say is a contrary interpretation I'm not saying is demonstrably unreasonable. What I am saying is that the state density bonus law does not mandate that you grant freedom from the R2 zoning prohibition. You are clearly not required to do so in our interpretation.
In your interpretation, sorry.
Can I jump in for one quick sec? Just for expedience perspective, I'm going to get to one area, which is that clearly the only seemingly clear case of this makes it very clear that for the purposes of CEQA, development standards, the waiver of development standards in a density in a qualifying density bonus project are not applicable for the purposes of this qualification. And that's clearly, it says it says development standards. So I agree with you that it says very clearly development standards. So nowhere from Wolmers versus City of Berkeley or any subsequent case do they address specifically non-development standards. I'll say it that way. Broadly speaking, and in the direction of what density bonus law has given us, and the government code that Jim referenced a second ago, 65915K, talks about the purpose that incentives and concessions means any of the following. It certainly talks about, as we talked about, reduction of site development standards, a modification of zoning code requirements, other regulatory incentives or concessions proposed by the developer. And it also says approval of mixed-use zoning in conjunction with housing projects in commercial, office, industrial, other land uses will reduce the cost of housing developments. They're specifically talking about land uses there as another of the incentives or items that would be waived in concessions or incentives under density bonus housing law. So for density bonus purposes, it's a very broad category, including land use provisions. I clearly identified for misuse zoning as an example if it's prohibitive in their land use zoning. So or other regulatory incentives or concessions proposed by the developer. So it's fairly broad from a density bonus perspective. I understand that the applicable law for this CEQA exemption only references development standards. I guess the perspective is it a logical progression that the same identification and the same process that Walmart versus City of Berkeley went through to establish that applicability of these waivable development standards on this qualifying factor, would they likewise apply to a concession? That's the judgment you're talking. We have is to make that leap from the development standard to the concession, which HCD and density bonus law has clearly done. I wouldn't say HCD. Density bonus law has clearly already made that leap.
Well, again, it depends how you interpret the phrase zoning code requirements. It's
No, I'm actually saying or reduce other land uses that reduce the cost of housing developments. I mean, it literally says as one of those factors, you can eliminate land use regulations.
well, again, we don't interpret that as mandating that you forego enforcement of a clear land use prohibition. And we're not even getting to the demonstrated cost reductions part of the question either, again, which is.
Barbara, would you mind commenting on that? I want clarification on that.
On the demonstrated cost reductions. The language of each of the concessions talks about reductions in costs. But the lead case on this, and I will say in the past, many of our clients required developers to show that the concession was necessary for them to provide the affordable housing, did an economic feasibility study. But the lead case on this, on concessions, which is Schreiber v. City of Los Angeles, first of all, it said that a city needed to make no findings whatsoever to approve a concession, that a city could request a developer to provide evidence that the concession would reduce costs, but the burden of proof was not on the developer, and that the only way that a city could deny a concession is to make one of three findings. One is if the city itself had substantial evidence that the concession would not reduce costs, or if the concession created a specific health or safety impact or an impact on a project listed on the California Register, or if it violated state or federal law. The case went on to say that economic feasibility studies were not required of a developer to grant a concession. So the case substantially limited the ability of cities to deny a concession, barring really some health or safety impact, or the ability, which is very difficult, to demonstrate that the concession wouldn't reduce costs, or that it clearly violated a state or federal law. For instance, a concession to get rid of best management practices or the need for a water quality control board approval, you could deny because that would violate state law.
Thank you.
Yeah. But if I could just ask you, you're saying that the city could do a study to determine architecturally or whatever, to determine whether one concession over another was cost savings?
We could look at the developer submitted some evidence that the use of an apartment house would reduce costs rather than having many duplexes, that would reduce costs. The city actually contacted its architectural consultant to see if the consultant could do a study to determine if that was correct. And essentially, without doing full plans for the project, it really was just not possible. And then the city would need to bear the cost of doing that.
I have Another question, though. I think at the planning commission meeting that you were asked the question, or was the planning commissioner supposed to look at the project as one project or separate projects? And your answer was it was one project.
That's correct.
So why would you only be comparing it to an apartment building? There's 6 single-family homes, there's 5 townhouses, and there's an apartment building on one project.
But the only concession they're asking for is for the apartment building. So the issue is, does use of the apartment building rather than, I guess, 12 or 13 individual units reduce the project costs? They're not asking for concessions for the single-family homes or the duplexes. So the only question is whether, I will say in the past, in connection with waivers, cities often attempted to do studies to determine if the waiver was really necessary and if the project could be built without the waiver. But there was another case, actually, it's one of the ones cited by Mr. Hurd. And the really significant part of that case was that it said that cities had to grant waivers for projects as designed, again, unless you could make one of those 3 findings. Well, actually, the findings are a little different. Unless you could decide it had an impact on historic, health and safety impact, or violated state or federal law. So the courts have been moving, unfortunately, really, with much broader, the courts have, to the extent the legislature has not expanded density bonus law, which it also has done, the courts have also substantially expanded density bonus law. And perhaps I should mention that one of the authors of that decision, the Bankers Hill decision, a different Bankers Hill decision than the one we've mostly been talking about, is now the Chief Justice of the California Supreme Court. So, so the attitude of the courts has been very favorable toward density bonuses and to really expanding, to diminishing cities' ability to attempt to deny them or control them.
What would be your analysis of what is the point of having, say, Builder's Remedy or SB 10 or SB 9 if all a developer has to do is ask for a concession from anything? So why would the legislature keep creating new laws to undermine zoning if zoning didn't matter?
I'm not sure I can answer that question. I always am surprised when developers use Builder's Remedy because the density bonus law is so generous. In terms of SB 9, that relates to single-family homes, and so most projects would not qualify for density bonuses because they wouldn't include affordable housing.
Right, but what I'm trying to ask is the legislature, as you're saying, is trying to not have cities have restrictive zoning about housing. So if a concession could just eliminate everything, why wouldn't you just say a concession limits everything and we don't need to keep passing any laws? And in fact, what's the point of having a zone, and the entire state of California could just be zoneless because every developer could just ask for a concession? I know it sounds funny, but I don't mean it that way because I'm confused.
I'm sorry, I wasn't laughing at you. It was
I know,
just
but
like,
I'm trying to be a little bit logical here and say, well, for some reason, the legislature has not eliminated all zones. And yet it sounds as if a concession just can ask for anything and it erases it.
I mean, there are, there's the health and safety limits and there's the state law limits essentially on a concessions. Also, the number of concessions that a project can get is limited, which is different from waivers where they can request an unlimited number of waivers of development standards, but only 1 to 4 concessions project is only entitled to one concession.
Mhm.
In terms of, I think well, I don't,
Well, so-
I don't think my personal views of this state housing
Okay.
legislation are relevant.
Well, so I think that part of R2 has a number. I don't remember what it is, 19 something .030 maybe. About the apartment prohibition.
Right.
030. So 010 is permitted uses versus prohibited uses.
Correct.
So at that point, the permitted uses are two-family dwellings, or if necessary, you could do the single-family homes in R2 as well.
Right.
That's allowed. Why would they not need a second concession to eliminate that? The permitted uses. They're using a concession to eliminate prohibited uses. Wouldn't you need a concession to eliminate permitted uses? The permitted uses are only two-family dwelling
I think
or single family.
if the prohibition is removed, the apartment house is allowed. So that would,
Even though permitted only says, it says it can only be two-family units or whatever. it
effectively,
says.
it would add the apartment house to the list of permitted uses.
Oh, okay.
Can I follow up a quick question that Jane asked, which was the concession applicable to the apartment building and only the apartment building? The application as presented to the Planning Commission, because I know we're not looking at that, but as presented to the Planning Commission last month, had waivers and incentives associated with the density primarily delivered by the apartment building applied to single-family homes, which likewise seems inconsistent if you're only applying a concession to the apartment building when arguably the concession, the cost of the overall project may not be cheaper with the apartment building relative to the houses as well. Meaning you could deliver the density in a different manner than the houses and the apartment, and arguably not be a less expensive approach, thereby validating the concession. And you've said that the concession only applies to the apartment. I'm just drawing the inconsistency that the project is a project, the entire 2.3 acre site. And the benefits of the density primarily almost exclusively generated by the apartment building is benefiting the size and location and the subdivision elsewhere on the project. So in small part or in large part, we haven't looked at that exclusively on that basis. So it seems inconsistent that on one hand, we're looking at the apartment alone. On the other hand, we're looking at the project as a project.
Well, you could, if you could, if it was possible to develop this, look at the project as a whole and determine whether the project as a whole would be less expensive, if the apartments was converted all to duplexes versus the apartment house. But as we said, we tried to explore doing that, and
the burden would fall on the city to make that proof.
Burden would fall on the city and to develop substantial evidence. to
Yeah,
do
I'm
that.
not saying the standard is different. I'm just trying to understand that inconsistency.
Yeah, it can, yeah, but there's only, I think we're saying that the concession is only represented to allow, requested, to allow the apartment house.
Understand?
Yeah.
Separately, I want to follow up on a comment that Ms. Manley said relating to that no individual factor is unique on the project, on the property, or on the evaluation, which may be only her statement. I'm not saying everyone else is saying that. But that the combination of these unique factors makes it unique. Is that a standard by which we can look at the unique factors? Is it because the SET memo and the staff report previously, and its identification of it now, talked about individual elements that are not dissimilar from other projects or of this exemption, but is the combination of them a factor that is to be considered?
But what what, excuse me, what the Berkeley Hillside case said, it was an issue of site or location. I think you could, if the commission so desired, look at this combination of factors and decide that they're unique to this site, or that makes the site unusual.
Okay, thank you.
Yeah.
Any further questions for the two parties represented in this section? Seeing none, thank you very much.
Thank you.
We will now open the public comment period. And I'm sorry, Madam Clerk, I did not announce the numbers and putting your name on a card before. Were we doing that?
Yes, oh, go ahead.
I think in terms of the agenda, the appellant will get a rebuttal before we open. the
You're
public
absolutely right.
comment.
I'm sorry.
Sorry, and I know a lot of folks have a lot to say, but just cover a few things. First of all, HCD has weighed in definitively on the issue of concessions for things beyond a development standard. On December 14th, 2021, they wrote a letter of technical assistance to the city of San Jose. In that letter, they said, while waivers are restricted to development standards, concessions is intentionally broad. And they go on to say that the definition clearly indicates requirements beyond development standards are eligible for concessions. The statute clearly identifies regulatory requirements that are proposed by the applicant are eligible for concessions. So in HCD's mind, which the courts have now said, we're looking to HCD, this is settled. I've used this. I did a project in Pinole, it was 300 units, 51% of it was required to be commercial. Well, there's no demand for commercial. So we used a concession on the use requirement for commercial as an actual cost savings, because no one wants to rent commercial space right now. And we did 100% residential project. So this has been put to bed along the same lines as you were indicating by HCD. Others will say it's just HCD. Well, we've now seen from Southern California that it's HCD. A few other comments here. We're getting real technical, and I think it's incredible what the council has looked at, but go high level for a second about the infill exemption. It has a public policy behind it. It says, when you're up at Phoenix Lake, that's not infill, okay? But when you're in the middle of a developed area, that's where we want the stuff to go, and that's where it's less likely to have an impact. So just keep that in mind. That's the purpose of the infill exemption. And in this case, it doesn't say adjacent, it says surrounding. This is completely surrounded by a city. And I would note that the BLPOA attorney acknowledged that the lagoon serves homes well beyond those on it because it is a stormwater detention basin. Because the courts are so interested in a city's general plan, I'll just give you a couple quotes from, it's better to hear it from the city than from me. Page 93, your general plan. The city is urbanized. Okay. Belvedere Lagoon is considered low quality habitat for biological resources. Residential use and treatment of the lagoon with dyes reduces the viability of aquatic habitat. Recreations in Belvedere include the Belvedere Lagoon, page 109. Native soils were excavated from the existing lagoon areas and placed as fill to form the streets and paths, page 157. So there's a lot of clear statements in there about what the lagoon is. Briefly about the Army Corps of Engineers and Regional Board, that came up later in this process. And that is because in an effort to fight the development, people went to those agencies seeking clarity on the regulation. I think that in the future, we will look back, Belvedere will look back and probably really, really regret that because of the hoops you have to jump through. We just heard that the water is allegedly, the lagoon is allegedly waters of the United States. Well, waters of the United States are open to the public. They found that out the hard way in Seadrift, where they went to court and a gentleman wanted to sunbathe at the mean high tide line or lower and sued and won. If it's a navigable water, if it's connected to the bay, if it's waters of the public, anyone can come down here and use the lagoon. So these things need to be reconciled here. Geotechnically, still going to strongly encourage you to bring up our expert. But I'll tell you this, Thompson Dorfman is selling the concept of lagoon front living. The last thing they want to do is build costly homes around it and fill it up with sediment and have it slump in. They're probably have the most interest in being sure that something bad doesn't happen to the water feature that is the front yard of these homes. Super important. I think the final thing I'll say is that the suggestion that let's do an EIR so there can be a public process, the amount of technical reports done for this is unprecedented. They've been on the city's website for over a year. We went till 1:30 a.m. at the PC. Hope we don't make that tonight. But the public comment's been voluminous, absolutely voluminous. And final comment is the assent memo used the initial study checklist to check for exceptions to the exemption. They didn't find any. They said there's nothing that pulls it out. So that's an independent peer review. Thank you.
Thank you very much. Madam Clerk, do we know how, I did not introduce, I apologize, the numbering system that you had proposed. Should we call people from the public comment as they show up?
We do have about a dozen index cards that were filled out, so we can
Start with
call-
those?
Yeah.
Okay, so open the public comment period. And why don't we start with those? We'll call up 3 at a time, and one could please present and the other 2 stand in reserve to keep it moving along as best we can.
So we have Jill Nash, Jim Hornthal, Bethany Hornthal.
Jill, before you go, can we take a 5-minute break just to, thank you.
And I did not do, how to do something until I understand that. It's not a problem.
Thank you. I'd like to reconvene the city council meeting. We are about to begin the public comment period. And Madam Clerk, would you mind calling the three names again?
I was just told Jill Nash will be on Zoom later. Jim Hornthal, Bethany Hornthal, Ken Johnson.
Yeah, no.
Hang on. Oh, hello?
Yep.
Okay. Thank you. Good evening, council members. My name is Jim Hornthal, and I reside at 13 Peninsula Road. And as a local resident, a member, one of 650 members of the Belvedere Residents for Intelligent Growth, and a professor at the UC House School of Business, I'm here to voice my concerns about the Mallard Point development, specifically regarding its environmental and financial impacts on our community. I stand with the Planning Commission's unanimous decision against the Segal exemption for this project and urge the council to do the same. The Mallard Point project represents substantial environmental risks, including threats to our local ecosystem and water quality, elements vital to Belvedere's unique identity. At Brig, we believe intelligent growth means also thoroughly understanding and evaluating potential environmental risks and being environmental stewards for future. This can only be achieved through the empirical assessment and careful deliberation provided by a CEQA process, which is integral to making responsible community decisions. The proposed Mallard Point project represents the city's most extensive residential demolition to date, posing considerable financial implications for the local community. Should the development lead to direct or indirect environmental harm, there's substantial risk the developer might lack the adequate financial means or the dedication required for effective environmental remediation and restoration. A key reason developers prefer using LLC structures for their projects is precisely to minimize their personal liability and exposure in situations that may involve lawsuits, debts, especially those stemming from possible environmental damage. To protect our community, I recommend the council demand robust financial projections, including protections, including significant or irrevocable completion bond and extensive insurance coverage to ensure accountability and financial ability should environmental restoration and remediation be required. Stakes are high, and it's crucial for the council to thoroughly assess these risks and hold any large development accountable for its financial impacts. And I trust the council will make a decision considering the long-term environmental and financial well-being of Belvedere and its residents. I want to thank you for your time and consideration in weighing these important issues, and hopeful the decision will reflect the best interest of Belvedere and its community members. And it was said earlier tonight by staff, it's far better to be safe than to be sorry. Thank you.
Good evening. I'm Bethany Hornthal, also from 13 Peninsula Road. And I agree with Riley Hurd that we should call a spade a spade. And what I saw as I looked across the lagoon at the incomplete story poles for Mallard Point, and what I see as I read through the appeals for exemption and waivers, is a modern day Trojan horse. This development is ostensibly a gift, like the Trojan horse, of compliance with state housing laws. Yet, once inside our city gates, it can detrimentally impact not only our affordable housing landscape, which currently consists of 22 relatively affordable duplexes, but also our sensitive lagoon environment. We need development that genuinely amplifies affordable housing in Belvedere, not projects that reduce it under the guise of state law compliance. We need development that complies with our environmental guardrails, namely CEQA, not assumes exemptions from them. Do any of us think we really know the true scope or strategy behind this project? Are we left to merely trust the developer's current assertion that this project will have no significant impact on Belvedere's air quality, water quality, noise, or traffic? A vote for CEQA is a vote for vigilance, transparency, and safety. A vote for CEQA is a vote in favor of weighing the true impact of Mallard Point and not underestimating potential consequences until it's too late. You are the guardians and the gatekeepers of our city, Belvedere. Let us not become another ancient Troy. Thank you for your thoughtful consideration.
Thank you, California Supreme Court members. So I have a little time. I can be funny or try to. I'm impressed. I really am. I mean, what it takes to be able to ask the questions you've been asking requires just oodles and oodles of time. And I'm not going to use my time up saying the nice things, but it's true. And I thank you. First off, there's a lot of letters that I've seen on the website of people who don't live in Belvedere. And so I'd like to just quickly go through from our perspective the BLPOA. The BLPOA is not a homeowners association. Everybody knows that, but outsiders may not. It is a property owners association. It pays property taxes for the property under the water. The BLPOA is legally responsible for the waters of the lagoon. The waters are bay waters. All the restrictions that apply to bay waters apply to the lagoon. BLPOA's backyard is 68 acres of water, bay water. So not in my backyard is a very important environmental issue to the lagoon, to the people who live on the lagoon, the city, and the other residents. But we have an obligation under our law that we operate under. We have tremendous, it's not just putting water in, putting water out. There's $400,000 a year in the budget to manage that water, to make it environmentally acceptable to return to the bay. It's a high duty. Referring to the state license we operate under, 4.3.7, quote, manage the lagoon using the most effective, environmentally friendly methods available, considering that the waters of the lagoon empty into Richardson Bay. That's our duty. We're not weaponizing. We're not delaying. The public comments are insulting. This is our duty to protect this water, and that's why we're here. I believe in the city's general plan, some hazard, whatever, quote, filled land that is underlined by compressible materials, bay mud, marsh, should receive special attention during site planning. Okay, that brings up the question of sequencing of what's going to happen and when it's going to happen. We seek your help. We seek the developer's help to commit to doing a bulkhead prior to demolition. It's in their best interest, it's in the water's best interest, and it's in everybody's best interest. I don't know why they haven't said they're going to do that. I don't know why they haven't put it in their plans. We've been talking about it for 2 years, but I think the burden is on them. They're the ones that said they want the best project. They're the ones that say they have the best interest. Step up and say, we're going to do it. Why fight it? The next question I have, it's not particularly on point, but it was brought up about 2,000 linear feet of bulkheads on the lagoon over, I think, 6 or 8 years. That's apples and oranges. We're dealing with 3 football fields of shoreline here. Now, you take a 60-foot bulkhead on an individual house, it doesn't have the same issues. It just is not the same. It's apples and oranges. It's not a criteria. The man-made issue is not the test. It really isn't. The San Francisco Bay is now man-made. Look at the changes it made. But I'm not going to go into that. I think you've been kicking that back and forth. Question, and I tried to get it on the break, but maybe somebody can comment from the staff before. There seemed to be an indication that if this goes back to the Planning Commission, that the Planning Commission could somehow solve the problems that we've been talking about. And I asked if the planning commission could order the property owner to replace a bulkhead. And I think that question is still up in the air. To date, I don't think the planning commission has ever been empowered to do that. We have two former planning commissioners on the council. They, I'm sure, will know the answer to that. I think others are going to speak to the burdens here. The issue may be a significant impact, is a very low threshold, as your own attorney has advised. So I think that you think of the whole picture that we're looking at here, it's tough. It's not easy. But we have to find a way in which we can protect this just valuable resource to the city and to the people who are involved here. Because if they want to do it, they can do it. Why are they not wanting to do it? Thank you.
Karen Atkin, Jill Barnett, Tom Price.
Karen is on Zoom and she's ceding her time to me, so I don't know if you need to check that out.
She does need to say, I believe she's ceding her time. So one moment, let me find her.
We'll let Tom go first.
And
Okay.
when you guys get to the mic, could you just please state your name so we have it for the record? Thank you.
Mayor Mark, ladies and gentlemen of the City Council, thank you for all you do for our city and guarding our well-being. My wife Gwen and I have lived on the lagoon for 47 years in 3 different homes, all on the lagoon. We've raised our 2 sons here. Our youngest son and his wife and child just bought a house on Hillarita. So Belvedere is a wonderful place to live because of our very special community atmosphere. As I presented to the Planning Commission, a project of the size of Mallard Point needs to be thoroughly vetted and evaluated. The Planning Commission unanimously agreed that a CEQA exemption is needed or denied, and facts prove the project does not qualify for a exemption from CEQA. We as residents of Belvedere need to know. We need to know what would happen when the big earthquake comes. We built our homes on Peninsula Road 20 years ago and we put in a floating foundation because of the soils. Our 2 previous homes on the lagoon, we put a marble on the floor, and by the time it hit the wall, it was going pretty quick because of settlement. We need to know what effects this project will have on our cherished lagoons that we swim in, sail in, and enjoy year round. We need to know what effects the demolition of the current Mallard Point duplexes and disruption during the production of this huge project would be. We deserve and need to know what effect this will have on Belvedere. The developer and his council followed the roadmap laid out by Mr. Hurd's page of his favorite book, The One Thing, which basically says if you say something enough times, people will believe you. We are not part of a national political campaign, but a community facing an unknown. We can't take anybody's word, no matter how many times it's repeated. We need to know. Thank you for all you do.
Karen, can you please state for the record that you're ceding your time?
I am ceding my time to Jill Barnett.
Thank you.
I'm Jill Barnett, resident of Belvedere. As a reasonable, authentic woman, I believe truth is important and non-truths must be identified and called out. Many statements by the Mallard Point developer repeated over and over to the city and the media are not true and reflect on the honesty of both their stated intentions and their hired consultants who claim that the project does not represent an environmental risk. In a January 21st IJ article, Bruce Dorfman says, quote,
The 40 Residents Project was a collaborative effort with the community, and that the developers met with residents, stakeholders, and city leaders to come up with a lower density sustainable plan that also addressed housing needs. We came up with a plan that really was based on community input. Really? Did he meet with a few residents? Yes. Did he collaborate? Hardly. Over 250 Belvedere residents showed up at the November 14th Planning Commission demanding a CEQA review to prevent environmental catastrophe. Did Thompson Dorfman collaborate and address these concerns? No. He commented to the media that they were, quote, emotional appeals of some of the neighbors. Mr. Dorfman and his team constantly refer to his project as a pipeline project. It is not a pipeline project. HCD's published guidelines state a pipeline project must have design approval and a clear timeline. Mallard Point has neither. It doesn't even have financing. It's not a pipeline, it's a pipe dream. Mr. Dorfman states the town has delayed his project. The delays has all come from the developer's side. The developer did not pay fees in a timely manner, keeps changing the plan, and has submitted incomplete reports. He needs to spend more time fulfilling his obligations and less time complaining to the media in an attempt to circumvent the requirements. Here's a good one. Dorfman's team claimed that Mallard Point project did not have sidewalks because Belvedere residents like to walk in the street. Do we really believe that? Or rather, do we think he's trying to avoid using property to maximize the size of his project? The developer can't blame their desire to trade safety for profit on Belvedere residents. So I ask you, can you trust these guys? Belvedere must require completion of a CEQA review before permits are issued or demolition and building starts. An environmental impact report from an authentic, trustworthy, impartial third party to protect the health and safety of Belvedere and its residents, and to allow them to participate in the process. Thank you.
Larry Storr, Bill Watson, Susan Clough.
Thank you, City Council members. I just have a few pictures I wanted to show you of the bulkheads around, that's been a subject tonight, around the Mallard Point area, just so you a little bit more familiar with what's going on there currently. And also to put in some substantial evidence in support of the requirements for doing a environmental report around the soil geology, because and to refute what we heard from Mr. Hurd, that there's no evidence of settlement. I got a different thing up here, but you want to go to the next slide? It's just typical, what we call a bulkhead. It's rocks piled up. They really don't support and prevent any sort of flow. Next slide. These were taken in 2016. I was at the time on the BLPOA board in charge of operations, and we were trying to go around and encourage our members to upgrade and improve their bulkheads. There is no code in the city code requiring it. The city doesn't require bulkheads, so it's a voluntary thing. But we want to try to maintain the property from sliding into the lagoon, and they do deteriorate over time. Next slide. Another one. Next slide. This is a picture looking at Mallard Point from towards the south, towards the city. The house at the very end there is the big house on the end of the point that they're proposing. And those other structures are the duplexes. I just wanted to show you the orientation. The next slide is looking to the west along the waterfront there. And what I wanted to point out is if you look at those docks, they're sloping towards the shore. That's evidence of settlement of the properties. It's existing, it exists now. And so bulkheads are supposed to contain that. The problem is the original bulkheads were all sort of on the surface of the bay mud. And they maybe held 1 or 2 feet of soil on top from eroding in the lagoon. When you start putting heavy buildings on the sites, they're going to settle. And so an engineered design bulkhead is required. Next slide. Just another view of that. Next slide. So I'm gonna just speak from a little bit of experience, my experience with a FEMA home next door to me. This piece of equipment demolished the house. While that was going on, my house was shaking like mad, being on pudding like we are on here. Next slide. They went ahead and built these planter boxes. They're
My name is
concrete.
Bill Watson, and I'm ceding my time.
Oh, thank you. Okay, thank you. I didn't need that. These are planter boxes made of concrete that were put at the edge of the property on the bulkhead. The one nearest to you can see after it was constructed, topped over and broke the bulkhead. So this is an important thing to be considered, and the geotechnical side is very important, especially when you're dealing with big structures. One other thing is, even though the city doesn't have a code for bulkheads in the lagoon, we do have a policy in the building department that requires engineered structures for new FEMA homes. So this project will require a fully engineered bulkheads to be put in place by the city by policy. It's not in the code, but it is in our policy. And you heard the BLPOA did develop some standards for bulkheads for the homeowners with the city. That was for replacement of bulkheads of the existing homes. When you start dealing with FEMA homes, you're adding a lot of weight to these lots, and they cause them to move, as you can see here. And so the city developed this policy as a result. Our engineering that we did for the vinyl sheet pilot would not be sufficient for FEMA homes. Next slide. I think that might be all my slides. Thank you. I forgot, I wanted to add that all that movement, I wish I'd known about all that movement when that house was being demolished from the backhoe crushing the home. You wouldn't think it moved the house so much, but things fell off the wall. And I wish I had known enough to take pictures of my slab in my garage, because after the whole thing was over with, I noticed new cracks in the slab, but I couldn't prove that they happened because of that construction. So I think it's really important. We need to protect the neighbors. These things, well, we're dealing with saturated fill, not just fill, saturated fill. The water table is like 1 or 2 feet down. And so that it's like living on pudding when things move around. So thank you.
Andy Barnett, Steve Silverstein. Oh, I apologize. I'm sorry.
Thank you very much. Can you hear me? I'm Susan Clough, 9 Peninsula Road. What we've heard tonight is the city needs good, solid evidence this project won't harm the environment, public health, or safety. But the developer's applications, plans, and reports contain a lot of inaccuracies, omissions, and inconsistencies. And Ascent's review memo then relied entirely on applicant-provided information. It doesn't stand up. Let me give you 3 examples. And these go outside the lagoon as well as inside the lagoon, I guess. Drainage, timelines, and demolition. So drainage. With all our worries about flooding here, stormwater is a big concern along with pollutants getting into the lagoon. Their plans are to leave existing pipes and outlets as is and build some bioswales around the property for site drainage. Yet city steps and maps show that there are existing drainage culverts that run directly under their property. These carry stormwater from much of the east side of the island down Laurel, under the park, Community Road, then run under the proposed apartment building, private road, new homes, and into the lagoon. That's why it floods there. That's probably why there's subsidence there. Those pipes would need to be rerouted, upgraded, or replaced as part of the project, but they're not shown on plans. And in their subdivision application, that was the first 23rd of January 23, Mr. Dorfman checked no to the question if they were changing existing drainage. It's not possible. It doesn't stand up. Now let's look at the timelines. Their original, which is what you use to look at impacts, of course. Their original construction management plan states a clear 2-year timeline for demolition and construction. That's what Ascent and the technical consultants based their studies on. But that's all being changed. In May last year, the developer asked for extensions, 2 years for each home and townhouse duplex, 3 years for the apartment. In November, Mr. Dorfman told Planning Commission he may build the project over 4 years, or 6 years, or 20 years, or sell off the parcels to others. The longer the project, the greater the impacts, but there's been no updates to the consultants' reports or recommendations. As said, it doesn't stand up. Lastly, one of the project's activities under CEQA is demolition, but most of their technical reports don't mention it. The demolition application is for 2,000 cubic yards of debris. That seems kind of low for 22 older homes, patios, decks, docks, sheds, pavement, utilities, pipes, drains, and every tree and bush. But then their air quality study says 7,200 cubic yards for structures and pavement, plus another 1,500 cubic yards of exported soil. That's 5 times more impacts and off-haul trips, even before construction starts. So how's that calculated? Which number are we going with? It doesn't stand up. I could go on, but I've used up my time. So I ask you to protect the health and safety of our fragile environment and deny the applicant's appeal. Thank you.
Andy Barnett, David Parquet, Steve Silverstein.
Andrew Barnett, Peninsula Road, Belvedere. The council has a lot of leeway in making the decision whether or not to require a CEQA study. A CEQA study will identify issues. It will determine mitigating steps to address those risks, and it will impose a monitoring system during the construction process. I don't think anybody would object to those 3 things: identifying risks, mitigating those risks, and then monitoring during the process. That's what we're asking for. Now, what would it take for Mr. Dorfman to do a CEQA study? The cost would be less than 1% of the cost of his project. And the timeline would be roughly 6 months. So we're asking him to protect our environment at a cost of less than 1% of his project and potentially a 6-month delay. Why won't he do that? Why won't he identify risks, mitigate those risks, and monitor for them? The simple reason is because it's going to cost him money. They're going to identify problems that his consultants, who are beholden to him, who he paid for, omitted. They don't talk about the culvert system running underneath the property. They conveniently miss a lot of things. All I'm asking for is that the council uphold what the Planning Commission recommended, which is that we identify risks, we mitigate those risks, and we monitor. Now, Ms. Wilkinson had a long discussion about, well, if it's 100 feet over 20 years, that represents 2,000 feet. Nature is very good at absorbing many small hits. It's not good at taking one big hit. Mallard Point project will represent a huge hit. The San Francisco Bay has been a drainage for the Sierras for millennium. But in an 8-year period during the gold rush, hydro dissection of the mountains resulted in a change in the depth of the bay. It became 1/3 less deep, and it was considered an environmental disaster. For thousands of years, they absorbed water, but in 8 years, because it came all at once, it caused irreparable damage. Please follow the recommendations of the Planning Commission, and let's have an impartial examination to identify risks, mitigation of those risks, and monitoring. Thank you very much.
Good evening. My name is Steve Silverstein. I live on Cliff Road. I've been a resident of Belvedere for 28 years. I was appointed by a previous city council to be on the Parks and Open Space Committee, which I served on for quite a few years, and also to the Library Agency Board, which I also served on for a few years. On Cliff Road, there are a bunch of big construction projects going on now. And in fact, in my 28 years here, I've seen lots of construction projects. And I understand people who don't want more construction projects, but they happen all the time. And when these things are proposed, people make up every reason that they can think of to say, don't do this, don't do this. It's going to be the end of the world. Somebody builds something next door to me. But the fact is, because of the building department and the engineering and so on that's required here in Belvedere, these projects get done. The buildings get built substantially, and there's no damage that happens afterwards. So what we have here is a bunch of people who are afraid of something that is going to be mitigated, is going to happen. And what we have is a question right now: are we going to have 40 units on this property, or are we going to have 70? Okay, the CEQA report is going to drive up the costs and delay the project, which means it has to be bigger. Your staff and all your consultants told you that there is no need for a CEQA report. The Planning Commission did a little bit of what's called jury nullification and said, we don't have to follow what we're supposed to do here. You're being asked now to kind of review that and follow the rules, overrule the Planning Commission, or we're going to end up with a 3-story, 76-unit piece of construction. And legally, as we know, they could go for 100 units on that piece of property if they wanted to. So I ask you to use some political courage, stand up, do the right thing, and let this project proceed before it balloons into something that people are really going to be unhappy with. Thank you.
My name is Robin Watson, and I'm conceding my time to David Parquet. Thank you.
Thank you. Indeed, my name is David Parquet. I live on Leeward Road here in Belvedere. I hope you had the time to read my January 20th email. I really apologize for its lateness. I know you were up late. In that email, among other things, including establishing my own experience with CEQA, including environmental issues and CEQA process on a 50-mile long transmission line buried under San Francisco Bay, that terminated on 2 3-acre parcels on the end, with a much more significant project than this one. I understand issues in the Bay. I understand CEQA processes. I noted that staff has counseled you that CEQA provides 10 questions that you must answer. I know you talked about whether there's 10 or 3. For my purposes, I'm going to assume 10. That's up to you to decide. First 5 you have to answer yes to, each and every one of them. The last 5, if you answer yes, you have to deny.
I'm going to assume 10, but only one of those am I qualified to really talk about. Question 4, and that is, paraphrasing, does approval of the project have the potential for significant environmental impacts related to traffic, noise, air, or water? I firmly believe, given my experience, that there is that potential. And I believe you must deny the developer's exemption and proceed with an initial study. I want to underscore a couple of points. First, and very important, go back and consider the word potential. Doesn't say that you have to decide that there are environmental impacts. You have to decide that there are the potential for environmental impacts. That is not a high standard. Deny the developer's appeal. That potential must be decided. And that will be decided during the CEQA process. Second, since the commission's denial of developer's exemption, I think we have substantial new evidence. Since November 14th, you yourselves have approved the DEIR and FEIR for the Belvedere seismic upgrade project. Simplistically, that project is a bulkhead project to be installed in and adjacent to the Belvedere Lagoon waters. Well, so does the Mallard Point project, in addition to all of the other buildings that they have in addition to the seawall and the issues on the water. There are a lot of other issues there, not just the seawall. Those two projects, of course, have some similar, some identical, and some different environmental issues. In your own project CEQA case, the facts and conclusions that you found were that there were 16 potentially significant environmental issues, including many in the area of noise, water, and air. That is 3 of the 4 criteria in question 4. Today, no one, as opposed to what Mr. Hurd told you, no one can say that there are no impacts from the water from that lagoon on the environment. No one. Just like I can't say that there will be. But can't we all say that there's the potential? Here is your table out of your report, 20 pages of it, talking about summary of potential impacts on your seawall project. If I passed it around, it would take 3 seconds for you to find something that's potential. Potential, not certain. Every project is different. So that evidence I presented to the Planning Commission. So did the Tiburon Library project come to the same thing. In my experience, I looked at that one, and you cannot deny that there's not the potential for environmental impacts that are significant. Okay? If you agree, just on question 4, you have to deny the exemption. And I recommend, because of that, you proceed with the initial study. It is the initial study that will bring a lot of the concerns that we've all heard. I don't know this information. The developer equivocates, et cetera. I personally, in my experience, would not submit something to the extent that this developer has. It is not complete. May be deemed complete by staff for review, but the answer is it was denied. That would have been my experience. So what does the CEQA process do in addition to the transparency? It might be a negative declaration. Everybody's right on the developer's team, no impact. But assent itself, as my old professor said, is trying to jump a canyon in 2 steps. Yeah, when we get to the other side, all of these other alphabet agencies have decided that they're going to solve the problem, so there aren't any. To me, in my experience, that's an admission that there are potential impacts because they've just talked about it. So my opinion is, having done a lot of projects in California, all with successful EIRs, not just the San Francisco one, CEQA process is not some boogeyman. Does it cost money? Of course, but it's the perfect way for project details to be defined in advance so that full and complete consequences can be determined. It is transparent, as many of us have said. Second, to conclude, I am not opposed to the Mallard Point project. I'm not opposed to it. What I am opposed to is jumping the canyon in 2 steps. Let's do it the right way. This project, as the developer indicates, is very important to this community. But let's do it right. Thank you for your time. I don't envy your position, given what I've heard tonight, but thank you very much for your service.
Eugene Porter.
Belvedere City Council members and city administrators. As former, I'm speaking on behalf of myself, Eugene Porter, and my wife, Mary Loveland. As former 13-year residents at number 10 Mallard Road and current residents at 320 San Rafael Avenue, we'd like to take this time to comment on the proposed appeal to the CEQA provision imposed by state law, common sense, and our own Belvedere Planning Commission by applauding their decision and urging you to uphold it on the developer's appeal. We can personally attest to the condition of the existing bulkhead along the Mallard Road property. We've had ample opportunities to see the entire property from both the water and the land side. They're in poor condition. They are constructed from redwood and rock fill. The rock fill is holding up the redwood in place. Much of the redwood is rotten and water soaked after over 70 years of immersion and overtopping. Do not allow this project to proceed without a complete analysis of the bulkhead condition and their ability to support the proposed development. This is a proper and judicious use of the CEQA provision. Mary and I were among the first participants of the original Zoom call between the developers and Mallard Road residents when this project was first proposed. We were told existing residents would be protected, but our experience with the developer is contrary to those claims. The developer told us they wanted to partner with the city of Belvedere and create workforce housing and address local concerns. They have done anything but this. CEQA would provide a level of transparency that is absent in this process due to the developer's insistence on saying one thing to residents, something else to the press, and something else to the city council and building department. Mallard Road is the prime location for the city to build new housing. The more, the better, we say. We know the poor condition of the existing Mallard Road housing stock and utilities. We would like to support a common sense development that does not include a multi-story apartment building so that some developers can finance a new waterfront home where there is existing rental housing stock. There are many options to build and increase density without destroying views and existing rental units with access to water views and water activity. At present, the walk along Community Road in the Belvedere City Park and Playground is blessed with views of not just Corinthian Island, but also Angel Island as well. This is an irreplaceable asset to the community that is being monetized by the developer to the detriment of the community. Its environmental impact on the residents is precious and must be protected. We support a modification to lower the height of the proposed apartment building as it is too tall. The soil condition is poor for a structure of that height. The installation of pilings required to support a structure of this height will have severe and significant impact on surrounding structures, including this Belvedere City Hall, Public Services Building, and the park. CEQA will reveal this. There are
Porter,
drains from Belvedere
Mr.
City.
Porter, I'm going to ask you to try to wrap up if you could.
Just about done. There are drains from Belvedere City streets that cross Mallard Road to the lagoon. CEQA will identify them and assist in the planning their modification. Please reject developers' appeal to the CEQA provision. Please ignore their threats to build a bigger building with an increase in floor levels. Please require a complete and thorough analysis of this project before allowing it to be permitted. Thank you for your time.
Mayor Mark, Mr. Porter was the last index card.
Before we move to online attendees, anyone else in attendance who would like to speak who didn't turn in a card? Please state your name and step up.
My name is Hans Christen. We live on Peninsula Road, and I had really not intended to speak, but many of the points that were brought up need one little extension. That's the issue of liquefaction. I think that the fact that most of our buildings are built on not just a fill, but silt fill that was dug up and put on top of existing soil to make higher ground to build houses on. In an earthquake alone, the liquefaction has been documented in San Francisco in the Loma Prieta earthquake, I believe was the time. But when there is a continuous vibration going on for construction, that has a much, much bigger impact on the liquefaction possibility than a one-time earthquake. And I have a feeling that when there's 2 or 3 years of construction going on in that area, we're going to resilt the lagoon to an extent that we can't really quite measure yet or anticipate yet, but it will be us, the owners along the lagoon, who are taking care of the lagoon, will have to probably then come up with the money to get the thing back dredged again. So I don't know where that fits in, but it is definitely a cost or a issue that may come for all of us. Thank you. Thank you very much.
Thank you. Anybody else in attendance?
My name is Claire McAuliffe. I live at 229 Beach Road in Belvedere. First, I want to thank you all for a really fantastic meeting, tremendous work to get to the bottom of this very, very complicated issue. You have difficult choices, but you have to make them. And my comment really is from the standpoint of someone who has talked to a number of people in Belvedere who are like me, older people that will need housing like this at some point. And I think that that's a factor for you to consider. We also always hear the squeaky wheel, but then there are the people in the quiet side of it that don't want to really speak up, but I am speaking for them. And I know that you're going to make the right decision. You have a lot of history here with the staff report that said what it believed was right. And now you have to decide what to do now. And I'm confident that you will make the right decision. Thank you.
Thank you. Before we move to the online attendees, once again, anyone else in attendance here? Seeing none, Madam Clerk, raise hands online.
Yes, we have Luis Mirante.
Thank you.
Luis, you should be able to speak.
Hi, good evening. My name is Luis Morante. I'm Vice President of Public Policy for the Bay Area Council. The Bay Area Council represents about 350 of the Bay Area's largest businesses, and we work on regional problems like housing. I'm here tonight in support of this project, recognizing that the project contributes much needed housing to the region. The region produces and has produced about half the housing it needs every year for about 30 years. And that largely explains why the Bay Area, but also California, are such expensive places to live. I really want to thank all the people who've spoken up in support of this project. It can be really dispiriting as a young person who can't afford to own a home in the Bay Area to hear the voices of exclusion try to make that even harder for me to envision. And it's just really encouraging that there are people in the community that disagree with that and want to see a project like this move forward. In my day job, I work on state legislation and have contributed to AB 1633, which is a new law this year that creates penalties for local governments that frivolously deny exemptions that projects are eligible for. As I argue, this project is eligible for the Class 32 exemption. AB 1633 creates a $10,000 per unit penalty for projects that are wrongly denied using frivolous or specious environmental concerns. And I think the city of Belvedere could be walking itself into that trap if they deny the project tonight. I'd also point out that the builder's remedy applies to the city of Belvedere because it doesn't have a compliant housing element in the views of the state. And that invites, as this project proponent has already brought forward, a much bigger project. But there's a broader narrative conversation to be had about this. The legislature is increasingly willing to step into the field of housing, which has traditionally been a local government issue, in large part because legislators view local governments as not stepping up to the challenge that your constituents face, that their constituents face, that all Californians face, that of trying to provide enough housing so that housing in our region is affordable again. And as long as projects like this, which are perfect, which have affordable housing and are reasonably to scale with the neighborhood and follow objective design rules, perfect projects are denied, the legislature is going to increasingly ratchet up its authority to countermand cities like Belvedere and approve these types of projects. So in the interest of self-preservation, but also in the interest of the broader community, I strongly, strongly urge you to approve this project and to reject the specious environmental appeal brought forward to you. Thank you.
Jordan Grimes.
Yes, good evening, Council. Jordan Grimes, Resilience Manager on behalf of Greenbelt Alliance. We're a 65-year-old environmental organization operating in the 9-county Bay Area focused on climate resilience, open space protection, and sustainable land use policy. And we're here in strong support of the Mallard Point project tonight. This is the most significant and important proposal the town has seen in many years and would represent Belvedere's first multifamily housing development in 3 decades. Since there has been significant discussion both tonight and previously about environmental concerns, I want to be clear that from our perspective, not only will this project not harm the environment, it will ultimately be a significant benefit to it. Every day, thousands of people commute into Marin County over the Richmond Bridge in their cars. People who watch and educate and take care of your children, who teach your children, who maintain and keep your homes tidy and clean, who cook for you, who provide food for you, who bag your groceries, who deliver mail for you. The housing supply is so low and housing prices so high that all of them have to commute in, spending hours in their cars, emissions spewing out their tailpipes because they cannot afford to live in town or in the county. By creating more infill housing, this project will reduce vehicle miles traveled and greenhouse gas emissions, essential steps at the local level to limit the worst impacts of our climate crisis. Finally, Mallard Point is in the middle of a developed urbanized area by the city's own definition. It qualifies both in spirit and letter for CEQA's infill exemption. And it is concerning to us to see people misusing environmental law in an attempt to stymie new infill housing construction in the places where we need it most. There are many, many valid uses of CEQA, and it weakens the law when we have people misemploy it in order to further other concerns like those made tonight about view loss and building height. We urge you to acknowledge the validity of the infill exemption and approve the project. Thank you so much for your time this evening.
William Rothman.
Yes, thank you very much. William Rothman, can you hear me okay?
Yes.
Okay. 14 Cliff Road. Steve Silverstein and I are good friends, but we differ on the need for belief in the need for a environmental impact review. I'm particularly concerned about the pile driving that will take place because these buildings are big and they're not going to have a 4-foot piles. They're going to have to go down till they hit rock. And that's going to create the liquefaction problem, which was described in the seawall project, when everything begins to liquefy. And as they pointed out, that in their EIR, that can exactly duplicate what happens in an earthquake. We've got enough problems with real earthquakes without creating our own earthquake. Also, Councilperson Lynch asked a question which stimulated my thought, which was, is the lagoon a wetland? And Mr. Hurd said, oh no, in a wetland, you can't remove vegetation as they do in the lagoon, and you can't use pesticides. Well, Mr. Hurd is maybe he is an expert, no question, in the courtroom. About environmental concerns such as that, he's not an expert, and I know more than he does. Approximately half of the circle of the bay has marshland, wetlands, and they routinely use removal of vegetation, and they routinely use pesticides or herbicides, the form of pesticides, when they want to remove undesirable vegetation. So I really do think it is a wetland. And the fact that they use the algicides and the fact that they do remove vegetation in no way makes it less of a wetland. Well, I guess that's a gist, although I have to tell you, the last two speakers, particularly the fellow from the Bay Area Council, who wanted to tell us what his employers would like to do, that approach, like making an offer you can't refuse, more appropriate for some other areas where I grew up in New York than would be I think for California at this day and age. And the fellow from the Greenbelt Alliance, who said that people who clean your houses are going to be able to live in the buildings, obviously had no idea about what the rents and the sale prices were going to be. So I would urge you to require the CEQA. We just can learn more, and the more you learn, the more, knowledge is power, and the more you know what the right decision should be. So I urge you to uphold the Planning Commission's decision. Thank you very much for your attention.
Carmela Davis.
Hello, my name is Carmela Davis, and I work with the Marin Environmental Housing Collaborative, which is an environmental and housing organization that has existed in Marin for nearly 2 decades, advocating for projects such as Mallard Point. And tonight I will be speaking on behalf of MEC board member Paul Jensen. He's a 44-year Marin County resident and a retired city planner and community development director. And throughout his city planning career, he has managed many projects like Mallard Point, which included administering and authoring many levels of environmental review and exemption clearances under the provisions of CEQA. He would like to note that the Mallard Point project presents the best opportunity for the city of Belvidere to do its part in providing needed housing for Belvidere and Marin County. As clearly demonstrated in the November 14th, 2023 Planning Commission report and supportive documents and studies, Mallard Point is the right project for this location. The 2.8-acre Mallard Point site is one of the very few, if any, sites in the city of Belvidere that is suitably sized, level, and relatively constraints-free to accommodate higher density housing. The finding that the project is categorically exempt from environmental review under CEQA guidelines section 15332 is well-founded and is appropriate for this infill development. This exemption is supported and substantiated by the October 13th, 2023 memo prepared by Ascent. The city staff could have merely made this exemption finding relying on and tiering from the Belvidere General Plan EIR. However, in this case, individual site-specific technical studies on relevant topics were commissioned and conducted to provide a strong and defensible foundation for this exemption finding. Further, the city hired special counsel with extensive knowledge in CEQA to assist in reinforcing the infill exemption finding. CEQA laws provide the decision makers the ability to exercise your independent judgment. As city council members, now is the time to exercise this independent judgment. Should you, as the city council, determine that this project is not eligible for the exemption, please keep in mind the following. 1, proceeding with an initial study for environmental review will not likely result in any new or additional technical studies that have not already been prepared, and it will not likely result in substantially new or different findings and recommendations. Secondly, proceeding with an initial study is often done to open up opportunity for public review. Clearly, as demonstrated by the many public comments and engagement to date, the public review process has not been compromised or undermined. Thirdly, the staff report cites that the CEQA exemption and expectation provisions regarding the defining of the Belvedere Lagoon as urban use and/or unusual circumstance, respectively. Should these factors be used to disqualify the infill exemption for Mallard Point site, it has precedent-setting implications. Please do the right thing for Belvedere and Marin County and approve the appeal finding that the Mallard Point project is eligible for an infill exemption under CEQA. Thank you for your time.
Jim Allen?
I'm done.
Hi, thanks for all the work tonight. I wanted to fill in some of the history of how the lagoon was built and what was done to the environment before that happened. My grandparents are the original motivators to get the lagoon built. So here's a picture of drawn by an artist. Where is it? Of the area about 1880, before the railroad got here and screwed up the lagoon. So, you know, there's years and years and years ago, the environment was greatly changed. You can see the lagoon in its original form there. It was a big arm of the bay. It was very great nursery for all kinds of life forms, but it was filled in and has happened all around the bay. Hills were torn down and dumped in the water, and people who owned tide lots turned them into land, which is part of the history here. Anyway, this is how the water, how fast it ran in and out of the lagoon every day when it was still shallow enough, deep enough to anchor in there. By 1930, that was a thing of the past. It was so silted up that you couldn't get in or out by floating. And I think Belvedere's done a pretty good job of preserving itself. My grandmother grew up here when this was how it was. And when they bought the Belvedere Land Company, they had a lot of problems with all this silted up land. There were huge mosquito infestations that developed in the cracks between the mud, dry mud every year. And here's partway through the dredging process, 1937. They set out to try and at least restore some of the conditions, which by eliminating dust and mosquitoes, and those were the original ideas, not a big residential development. But when they got the first channel dredged all the way around the lagoon, they could see, there's potential here for waterside housing. And that's why they developed the lagoon. It was a very, very slow process, in part because of World War II, but in part because people didn't get it when they first saw the lagoon. So Mallard Road was built in 1951 as a marketing technique. They figured if people could live in Belvedere and try it out, then they would see how great the lagoon is as a place to live. And that basically worked out. Many of the early lagoon owners came from previously living on Mallard. So that's just a bit of the history. I won't grind an axe either way on the EIR. Thank you.
Thank you, Jim.
We have Jill. Jill, you should be able to speak.
Sorry. First of all, thank you to the council for your thoughtful consideration. This is clearly a complicated issue, and we appreciate your thoughtfulness. I have to say, I read with great interest the letters that have been submitted to all of you on the council. By my count, there were probably a little over 80 letters submitted. The overwhelming number are from Belvedere residents who agree that a CEQA review should be required. That said, I was particularly interested, as Ken Johnson noted, to see the number of people from Mill Valley who took the time to weigh in on Mallard Point. I have to say that personally, I don't ever recall feeling the need to voice my opinion on issues facing communities where I don't reside, but it warms my heart to know that there are so many people out there that care so deeply about all of us here in Belvedere. Tonight, Mr. Hurd cited a letter that was sent by Amy Skews Cox. In it, she stated that there's no need for a CEQA review for this project. In her letter, she identified herself as a CEQA consultant to Belvedere, who evaluated the San Rafael Avenue Beach Road infrastructure project. Interestingly, in that report, she identified 16 potentially significant impacts to the environment. Now, I've tried to do my homework on this project, and if I understand things correctly, for the review of the infrastructure project, which Councilwoman Wilkinson also referenced, there were 16 potential impacts. The Tiburon Library expansion review, that's in close proximity to both of the others, had 18 potential impacts. Now, Amy tells us that a CEQA review is unnecessary, but I'm wondering, how is that possible given the findings of these other two reports? Tonight, our city attorney acknowledged that all of this is confusing, and I couldn't agree more. So I guess my question to the council is this: why would we not want every piece of data available before approvals are granted? Due diligence, at least the way that I've been taught, is a good thing. And aside from common sense and good stewardship, it provides much needed transparency for our community. Transparency builds trust. And I think the one through line in a lot of the comments here is that there is a lack of trust. And I think we need transparency to try to rebuild that. So I encourage the council to vote for transparency and uphold the Planning Commission recommendation and require a CEQA review. Thank you.
Jenna Watson.
Hi, this is Jenna Watson. I'm a Belvedere resident. I live up the hill on Oak Avenue. I wanted to state that first of all, thank you very much to the council. I know this has been a lot of time and a lot of energy, and I'm sure a lot of education as to various housing, zoning, and California state laws. I just wanted to state that, you know, we seem to be getting wrapped around the axle on whether or not the project should go forward. That's not what's being asked of the council tonight. What's being asked of the council tonight is a fairly narrow question having to do with whether or not a full CEQA review is warranted. I wanted to also thank Jill Nash for her comments, in that many projects which would have lesser impacts than this project have CEQA requirements. So I would just like to state that while there's a lot of emotion having to do with this project, let's stay on the topic for right now. And I wanted to throw my support also behind having a full CEQA review. Thank you very much.
Mayor Mark, I see no other hands raised.
Thank you very much. Before we close the public comment period, we're going to give the applicant the opportunity to, applicant and the appellant to respond as well.
Thank you. I know we're all very eager to hear your deliberations, so I'll try to be brief. Once again, Bradley Hurd. So first of all, CEQA is complicated, and I'm hearing a really big misunderstanding of what you get with a CEQA review running through as a theme in these comments. And it's troubling because there seems to be some suggestion that if you do a CEQA review, it will make them do this, it will make that happen. That's not how it works. It's an informational document, and what you got from Ascent already is well beyond what's usually in something like this. So I want to point that out. Second of all, it's really quite odd to me that it isn't being recognized that these folks are about to spend tens of millions of dollars to improve this property. I can assure you they're the very last ones that want something falling into the lagoon. Okay? This is a big investment in them and in Belvedere. And I'll tell you right now, they will replace any and all bulkheads that require replacement as part of the city's building permit review. Fact. So there's also a misunderstanding about where we are in the process, right? We're at the planning entitlements phase, and asking people to have fully designed concepts, that happens at the building permit phase. This is entitlements, planning review, and this evening we're discussing CEQA. So I want to point that out. Third is the level of hyperbole that we heard. And I have two quotes: environmental disaster and environmental catastrophe. And I heard that the construction of the homes around the lagoon could be akin to the gold rush and the amount of sedimentation that occurred in San Francisco Bay. I mean, this just, it's so far from what a small scale housing project actually is and looks like in the real world that it's hard to rebut. But I can assure you, the controls, the building code, the alphabet agencies, doing anything is extremely, extremely difficult. And my final comment is, they say, you know, Mr. Hurd doesn't know this, Mr. Dorfman doesn't know that. Their experts don't know this or that. Fine. Take that as true and rely upon the city's experts, the ones that the city managed the acquisition and the work. All of those experts came together and approved a staff report that was written to the Planning Commission that said this project is exempt from CEQA. I really don't know what to say other than cut through all the noise, take out me, take out Mr. Wolf, take out Bruce. Your own experts landed that this was an exempt project. And I think that really, really goes a long way when you're talking about substantial evidence and legal standards and urban uses and infill exemptions. This is highly technical, and the experts say it's exempt. So we would ask that you find the same. And one more thing. People come up to us offline, out of the public view, and they say, not just, I support the project, they say, put me on the list. I want one. I need to get off the hill. I need to get out of my house. I want to stay where I live. And doing things like throwing up the kitchen sink to stop the project is not going to achieve that goal. And it's certainly not going to help with the state either. But tonight's about the exemption, and your experts weighed in on that. Thank you.
Thank you very much. Yes, you can. Briefly, please.
Excuse me, 30 to 45 seconds. We heard a representation of what his client will do if the building department makes a decision regarding the bulkheads. May we have that representation made by the owner? Thank you.
Absolutely, and we've made that comment before, and we will continue to do so. Thank you.
Thank you. So with that, we'll close the public hearing and certainly bring it back for deliberation. Just prior to that, do we have any clarification or questions to our city staff from what we've heard before we?
Well, I was going to ask, picking up on the comment from Mr. Storr, whether our code in fact empowers us to compel the applicant to build bulkheads that need to be done. It sounds like that question may be now moot or at least answered. I will ask though, can we condition this project, not us, but is it hypothetically possible to condition this project that the bulkheads would be repaired or built before any demo was done? Is that something that can be done?
I think, and Barb, correct me if I'm wrong, we can condition it that a final geotechnical review of the bulkheads must be done first and replaced as part of the first phase of construction as determined by the city engineer.
Thank you.
I think we can also, I mean, not we, but I think the city can ultimately condition an approval so long as it doesn't restrict the number of units, right? So, I mean, there's broader latitude than, you know, subsequent to a geotechnical requirement.
Sure, yes.
And one quick comment also on Larry Storr's comment. Are effects on neighbors' homes as impactful as it might be? Is that an environmental impact? I mean, certainly there are laws and liability and, you know, civil and criminal other circumstances should activities affect other personal property, but is it an environmental impact?
Well, if the project damaged other homes, that could be considered, you know, that's a physical impact of the project. The reports that were submitted and reviewed by Ascent did look at vibration impacts. I think those were raised, and effects of pile driving, and actually have some, you know, calculated the vibrations that would be generated and concluded that they met some standards set by I think the Federal Transportation Administration.
And Mr. Parquet mentioned criteria number 4 and kept using the term potential significant impacts. I understand the fair argument of potential impacts in relation to unusual circumstances as a second condition, but that seemed to be a pretty definitive, either it would or it would not from a fact-finding perspective, but the criteria is very clearly would not create significant impact.
Yeah, you're correct, Mayor. The standard for evaluating an exemption is there substantial in the evidence in the record that the project would not create significant water quality impacts?
Thank you.
Yeah.
Can I ask one additional question of staff?
Are we able to condition the project to require performance bonds? Because I know there's concerns about, non-completion of the project and all these other things. A performance bond something that we can require? And I was interested to know from the applicant whether that's something that's ever been applied to you before.
This project includes a tentative map, and as a standard condition of approval, any kind of public improvements or subdivision improvements, I think probably the city engineer can, anyway, all the improvements that are required basically to create, let's say, buildable lots can be, the city can require a performance, various bonds for those. And a pretty detailed construction improvement agreement is typically entered into. Maybe the Public Works Director wants to add, but anyway.
Okay, thank you.
Yeah.
Okay, thank you. Any more questions before we move to?
Can we just get that question answered?
Oh, sure. I didn't realize that they were. I apologize.
Sorry. But that is typical that we would provide bonds for all the public improvements, and typically the private improvements do not get bonded. The only time we've had bonded private improvements is when we're building workforce housing for public school districts as a part, because it's a public project.
Okay, thank you.
Jim, do you want to start with any thoughts and comments and discussion items?
I don't really have a lot of discussion items. I do have thoughts. I'm happy to give my thoughts on where I think this would go. I will say this was an extraordinary discussion, and I'm certainly grateful to everyone who contributed. I want to echo some of the comments we also received tonight, that this really is a limited scope of decision that we're making tonight. It's simply a ruling on this appeal. And a lot of the comments we got, which were helpful and passionate, related in some ways to the project, but unrelated to any of the criteria in the exemption or in the exceptions. Would you like me to keep going?
Oh, please. Yeah.
Would you like me to tell you what my thoughts are?
Yes.
All right. Well, let me begin with this. I expect that whatever the resolution of this appeal is tonight, there will be disappointment. And by the way, I have no idea how this council will come out. The developer and those who support this Class 32 exemption could be disappointed, or those who oppose granting the exemption could be disappointed. It's our job on this council. We took an oath to bear true faith and allegiance to the Constitution of the state of California, and to well and faithfully discharge the duties that we undertake. I know that and you can tell from this discussion tonight, this council has spent an enormous amount of time and energy trying to understand these issues and trying to reach the right outcome under the law. And this analysis, in my view, begins with a legal question, which is whether this applicant is entitled to a Class 32 exemption. And I think my obligation is to do my absolute best to understand the relevant law, however impersonal those fixed principles may be, and apply that law to the exemption before us. So, to those who may be disappointed, at least by my input, let me just respectfully ask that you accept that I thoroughly and tirelessly and selflessly have done my absolute best to reach the proper decision here. I would vote to grant the appeal and to allow the Class 32 exemption. Let me just begin with the 5 criteria. Well, actually, let me begin with what we're talking about. We've been advised to cover 3. I'll say we have to run, I think, through all 5, but we don't necessarily have to, in my view, articulate them. We believe that they're in the record. And that's the guidance we got from council. And I agree with that. I think the first criteria, which is this consistent with applicable general plan designation and so on, I think there's substantial evidence in the record right now to support that. I'm happy to discuss that further. We had a pretty fulsome discussion here tonight. It's been written up in full on the record, and be happy to discuss with my colleagues if that would be warranted. The second criteria is that the proposed development occurs within city limits on a property site of no more than 5 acres, substantially surrounded by urban uses. I find substantial evidence in the record supports the conclusion that the lagoon is an urban use. I begin with the Mammoth Lakes and the Bankers Hill 2006 case, that urban refers to constituting or including and centered on a city, and urban relates more to the location and varying characteristic of use rather than the type of use. I was struck by the acknowledgement from Mr. Wolf to a question that Council Member Wilkinson asked that I debated asking, and I thought it was a genius question, but I thought it was too much. What if you were at LA Country Club in Los Angeles, one of the biggest parcels of land in the city of Los Angeles? Would that golf course be an urban use? And Mr. Wolf acknowledged that it would be. And Mr. Wolf was acknowledging, Councilmember Wilkinson was asking about the language that comes out of those two cases, that urban relates to location and the varying characteristics of use rather than the type of use. And I believe that the location and varying use of the city and specifically that the lagoon is in the middle of the city, that it's man-made, that it's maintained and dredged. And I appreciate all the input from Mr. Johnson and the BLPOA about how important that work is to maintain it. But I find that lagoon is an urban use. It's in an urbanized area. It's densely populated. Belvedere has little open space. It has a variety of urban uses, residential, governmental, public transit, recreation, churches. And those factors combined with the guidance from the Mammoth Lakes and the Bankers Hill case lead me to the same the conclusion. Last, I think the qualified urban use standard simply doesn't apply for all the reasons that we said in the colloquy with Mr. Wolf. The fourth criteria is the approval of the project. The language here is approval of the project would not result in any significant effects relating to traffic noise, air quality, or water quality. We were guided that the record presently contains substantial evidence on all these factors except for water quality. I believe the record contains substantial evidence that approval of this project would not result in any significant effects relating to water quality. I begin with the assent memo, starting on page 19, which discusses the standards for hydrology and water quality, and asks a series of questions about what would be done to control and get assurance that approval would not result in any significant effects. That memo identifies that the project would be subject to the California Construction General Permit Order, that it would have a SWIP, stormwater pollution prevention plan. There would be post-construction stormwater management plan. By design, all runoff would be treated. The assent memo makes the case that because of the changes to that site as proposed, the quality of the stormwater runoff would likely be improved compared to where it is now. Discussion around the docks, but really the bulkhead construction is also addressed by the assent memo, where they explain that the participation by RWQCB, possibly the Army Corps, Fish and Game, all would lead to the conclusion that no significant effects would occur. I'm moved also, or motivated also, or my conclusion is supported also by the representation from the owners, the applicants here, Mr. Dorfman, and by staff who assure us that at the right time, the Planning Commission, together with staff, could condition this to make sure that all bulkhead analysis and work was done at the outset of the project. I'm persuaded also by the information that Ascent continues on page 20, which talks about whether the project would substantially alter drainage patterns or in a manner that would result in substantial erosion, flooding, or polluted runoff. There's a number of responses to that question that are set forth on page 20. And those are the basis among everything else in the record for my substantial evidence finding. Turning then to the third issue, which is the exceptions. There are 5 exceptions. It's correct that answering yes to any one of these dooms the exemption. The only one that we are facing in the scope of this appeal is number 2, which is that a categorical exemption shall not be used for an activity where there's a reasonable possibility that the activity will have a significant effect on the environment due to unusual circumstances. We are guided by the Berkeley Hillside case, and it's a 2-step analysis. The first question is there an unusual circumstance here about this project? And only if the answer to that question is yes, do you turn then to the next question. I find there is no substantial evidence to support the conclusion that there are unusual circumstances. Number one, there's already housing on that site. Number 2, it's the entire lagoon is surrounded, ringed by housing, and all of the peninsula roads and the pertinent roads possess housing. When you look at page 33 of the Ascent memo, it runs through the factors that it contends are not at all unusual here. And many of the factors that are identified as being unusual circumstances, in fact, according to the Ascent memo and the experts who have analyzed this, are in fact existing environmental factors that affect the project, not environmental impacts under CEQA. So I find there's no unusual circumstances. Let me next say that if there were to be a finding of unusual circumstances, which I would disagree with, I find that there's no reasonable possibility of significant environmental impacts. Although this is reviewed under the fair argument standard, my finding above and the analysis and the substantial evidence relating to criteria number 4, where I conclude that the project would not result in any significant effects relating to water, supports that second part of the finding. And that's the basis for my outcome.
Thank you. Councilmember Cooper?
First of all, I also want to join Jim and thank the applicant for their very complete presentation tonight and all the citizens who took time to write to us and show up and speak about the project. Going through, there's so much. It was a real challenge. It's still a challenge. I've taken many notes tonight, so although I prepared a lot of questions, there's still much that I learned tonight that has entered into my decision. So I know we've talked about Ascent a lot and the fact that they're authorities on this particular project. So wait, am I supposed to go through every one of them or can I just go to the
3 or
okay.
however you want to handle it.
Okay. So I'm going to just go straight to the urban uses one, since that was the first one that the Planning Commission addressed. And Ascent very clearly stated on page 12 that the lagoon is not an urban use. I can go ahead and read it, but I think everyone's probably knows what it says. So I guess each of us are going to look at authorities and decide which authority is meaningful, means the most to them. And I agree that Ascent has analyzed everything carefully, and their conclusion is that it is not an urban use. So I also think it's important that there's a natural interrelationship between the water in the lagoon and to Richardson Bay and ultimately the San Francisco Bay. I don't think that those bays are considered urban use. And although the lagoon is different, certainly the body of water in the lagoon does come from the bays and it does return to the bay. In 2008, there was a report done for our biological technical report for our general plan update. And it stated waters of the lagoon empty into Richardson Bay, and effects of this exchange of waters to surrounding areas should be considered in making management decisions for the lagoon. So I think there's a statement that actually could go to both, two of the different criteria that we're talking about tonight. But I think the lagoon and the bays are interconnected, and I'll leave it at that. The second thing was the approval of a project would not result in any significant effects for traffic, noise, air quality, or water quality. I think Miss Manley and Larry Storr both highlighted the fact that these bulkheads and Ken Johnson, the bulkheads have been a discussion, I think they said, for about 2 years. I guess I don't understand, and it's confusing to me. I do believe that this developer has very high standards and is looking to create a well-developed project. So I guess I'm confused why for 2 years, when they've owned this property, they've allowed the bulkheads to continue to fail and be substandard. And it's confusing to me why, given their statements over and over again of caring a lot, wanting to do what is right, I just don't understand why it hasn't been done yet. Perhaps there was no discussion with the planning department about it. Maybe there was no, I think there were discussions with BLPOA. So I think the bulkhead issue is important. I think as I've learned that in seeing and reading the Belvedere Tiburon Library EIR and our infrastructure project EIR that was highlighted tonight, I forget by whom, but it's interesting to me that each of those, both smaller projects than this, found significant environmental issues that were identified, and then they could become mitigated and then monitored, and hopefully would have no impacts after that. I do think understanding those things is important. And as Dr. Rothman said, knowledge never hurts. It's important. In our general plan update from 2010, which is the current one that we are under, there's quite a long statement about construction water quality impacts. and the impacts from construction primarily associated with infill and redevelopment, demolition, vegetation removal, grading, parking of construction equipment and other vehicles on site, the idea of related pollutants, leaks, and spills that may be discharged into the city's storm drains, corresponding urban runoff, and the end conclusion was that these constituents would result in water quality impacts to area waterways. So given that our general plan is highlighting the need to understand and take care, because all these things would result in water quality impacts, I think that's a strong statement for us to recognize. I know that noise was not brought up, but I did want to add that I am concerned about noise. This project is right across the street from our only playground. I do feel sorry for our staff as well, that they're so close to the potential of this. So I know that I'm not an authority on noise. I'm not going to pretend that I understand what DBAs are or LBNs or any of that. I tried to understand it and I gave up. But I think, again, in our final EIR for the infrastructure project, it was noted that pile driving noise reduction measures should be implemented. We were told that residences up to, I think, 16 feet away would be impacted by that. That there needed to be a noise disturbance coordinator responsible. And I think these are all mitigating measures that show that when there is a worry of any kind of environmental issue, there are things that you can have happen so that it is not a problem. If you don't know, if you don't do the CEQA, you don't know what the measures are to mitigate these. I realized that there were a lot of reports submitted, a lot of reports. And again, I'm confused why, when all these reports were being submitted, why wouldn't you have just done an initial study? Why not come up and say what the mitigating factors could be or would be, or what things might be significant or not? There certainly was a lot of effort put into it, a lot of money put into it, and it's confusing to me why that one next step wasn't followed. As far as unusual circumstances, I think are one of the choices that was given was size. And the development project, the Mallard Point development project, would be about 90,000 square feet, which is definitely the largest project in many years ever, probably in Belvedere. The next largest development that we have in Belvedere are the Arc Apartments on Beach Road. And that development is about 30,000 square feet. So actually the Mallard Point development would be 3 times larger than the next largest housing development. I think that's an unusual circumstance. The project isn't minor in scope, size, or density, and we can't with reasonable certainty know that it wouldn't have a negative environmental impact or effect on water quality and noise, and perhaps other environmental impacts. A reasonable person would assume that this project has the potential to result in either a direct or a foreseeable indirect physical change in the environment, given the size and location of where it would be. I think we've heard that this location is prone to liquefaction, to ground lurching, compressible marine sediments, expansive soils, and erosion. And I would hope that any development would plan for these to occur prior to creating final plans and getting permitting. I also truly hope that whatever decision is made tonight, that either way, the developer does not think that this is being denied and that the project could not move forward. This is simply about any kind of significant environmental issues facing our environment in Belvedere, which we know has a lot of issues. So with that said, I would support the Planning Commission's decision and deny the appeal.
Could I just ask one qualifying question, Councilmember Cooper?
That's not fair.
Just-
I didn't ask you any questions.
I hear, feel free to fire away. No, I think there perhaps had been a misstatement. You referred on the urban use, you referred to page 12 of the assent memo saying that assent said that it's not an urban use. And that's the page where they said it's not a qualified urban use. And when I was citing their analysis as part of my support and substantial evidence, I was referring to the previous page, page 11, last paragraph, where they identify a number of factors and say this may allow the lagoon to be considered an urban use. Just want to make sure that the
Okay, but
record wasn't ambiguous on that.
okay.
I agree with Councilmember Lynch that we should uphold the appeal. We have always said as council members when this question was asked over the years that this project has been cooking, that we would follow the law. We took an arm's length view until it was time for us to engage, but we always said that we would follow the law. And so I know that all four of us have spent an enormous amount of time over the last few weeks reading through thousands of pages of documents to make sure that we've considered all angles in our quest to follow the law appropriately and follow the law for everybody in Belvedere, and that this applicant should be treated the same as we would treat any other applicant in Belvedere. So to answer the specific questions, number one, I do believe the project is consistent with applicable general plan designation and all applicable general plan policies, as well as applicable zoning designation and regulations. I believe there is evidence that the apartment prohibition is a zoning standard and therefore qualifies as a concession, and therefore this standard is met. I think there is substantial evidence that this development is surrounded by urban uses, which is the definition that we are reaching to. As all of the case laws established, it's not what, but it's where. And I think it's very hard to argue that a man-made lagoon in the middle of a city surrounded by residences is not an urban use. I think that's too much of a stretch for me. So I do believe this is substantially surrounded by urban uses. In terms of the other questions, in terms of impacts, first in terms of the criteria, in terms of the water quality, and then the criteria in terms, sorry, the exception in terms of reasonable possibilities. The thing that I'm drawn back to here repeatedly, because we've heard so much conflicting information from comments from the public and various others, that I'm drawn back to this statement that is made in the Woolmer reading on unusual circumstances, which says this: a lay opinion is not substantial evidence. Unsubstantiated opinions, concerns, and suspicions about a project, those sincerely and deeply felt, do not rise to the level of substantial evidence supporting a fair argument of a significant environmental effect. And so I've taken that really seriously, and I've reviewed the hundreds and hundreds of pages of documents that have been submitted by our professionals and reviewed by professionals for the city. And I believe, in terms of all of the evidence that they've provided, that with all of the regulatory requirements that are required as part of this application, once it goes to the permitting phase, that there is no substantial evidence that there will be any impacts. I'm not sure I've phrased that the right way around, but I cannot see a reason why we should be concerned about any environmental impacts that would not be dealt with through the permitting phase and regulatory phase. And I do think, just to step back, some of the things that I've learned over the last few weeks is that, you know, CEQA, when CEQA was introduced, there's really not a lot of environmental protections in California, but subsequent to CEQA being introduced, there's been so many additional layers of environmental protections put on in California that it is extremely hard to build anything that isn't to the absolute highest environmental standards. So I have utmost confidence, and in terms of what we're required to do here, I believe that this project meets all of the criteria and doesn't meet any of the exceptions, and therefore qualifies for the Class 32 infill exception.
Thank you. And once again, I'd like to mirror a lot of what has been said, that this has been a lot of digging in deep onto subject matters, which to a great degree, I wonder whether we should even be digging into it on. I think it's important to zoom out a bit and consider the intent of the exemption, and consider the law and the guidance that we've received on the record. And this is where I think Sally had a valuable point, which is this is primarily a technical examination presented by experts, utilizing the significant evidence standard that we need to balance and weigh, if that makes sense, and if we understand that. And I do take that with a great deal of significance and importance. And when I was talking to Mark Wolf about the value of additional environmental study, whether it be initial study or further or a full EIR, that's significant. I see the value. I understand it's an information process, and it's greater transparency, the sunlight that we discussed. But that's not what we're asked to resolve. That's not what we're asked to evaluate. There's 5 particular qualifications and the exceptions. And moving to those, I'll stick with the 3 that we're asked to address. I do take that the established precedent in the law regarding urban use is, as Sally pointed out, it's not what, it's where. And I can make the finding for the case that, in this case, this lagoon is an urban use because of its surround and because of the applicable developments in an urbanized area. I think that the approval of the project would not result in significant significant effects related to traffic noise, air quality, and water. It doesn't talk about potential impacts. It talks about significant effects, which technically is a potential for a mitigated impact. So it's not talking about the potential for impacts. It's talking about that there would be an effect, an unmitigated, unresolvable effect. And we don't have any evidence that that in fact would happen. There's a broader standard, certainly in the second exception that we were additionally talking about. As Jim pointed out, the standard there, or the test to be satisfied, is that the circumstances of a project differs from the general circumstances of projects covered by this categorical exemption. So it's not how unique it is to Belvedere, it's how unique it is to projects of this type utilizing this exemption. And I take that seriously because while this is a big project for our community, it's not necessarily and especially in light of what housing law and housing intent of this state is, it's a pretty modest, pretty reasonable project. And I do think there are planning circumstances and subsequent approvals that still need to look at this project as we go forward. But on the exemption, I can find that the qualifications are met and that I don't see the exceptions qualifying either. So I can make the findings for upholding the appeal as well. So with that, can I ask for a motion to, I'm sorry.
Excuse me, Mayor. Thank you for the deliberation. So just as a procedural matter, just counting the votes from down here, I would urge the council members who wish to vote in favor of granting the appeal to also review the draft resolution that was included in the packet for this item. For the purpose of just cementing the record on this matter, it would be beneficial to have a resolution documenting the city council's decision.
I did it. Thank you,
So
Andrew.
that would be very much appreciated.
Thank you. I did have one comment, maybe a couple comments. Exhibit A, which identifies the findings. The first one, obviously, is the applicable general plan designation. I think we need a little more than that one paragraph that's in the resolution. I think we need something that more closely mirrors the language in the staff memo, the original planning commission staff memo, perhaps supplemented by Councilmember Wilkinson's very clean articulation of it. And then on D at the bottom, water quality. I think we should, to whatever extent we can, have language in there that refers to the commitment that came from the applicant this evening, that the bulkhead work would get done and could be done at the commencement of the project and before demolition. The second to last exhibit.
Are you, I think the combination of the comments, the intent of the approval of the appeal is pretty clear. Do we need to articulate it beyond the discussion we've had, which is on the record, or can we use that to amend the resolution thereafter?
So if I could make one suggestion, or maybe two suggestions. Certainly, if any other council members do have specific comments along the lines of what Councilmember Lynch just offered, that would be very much appreciated. I certainly understand it's been a long night and maybe those comments won't be forthcoming at this point. Perhaps the motion could also designate someone to work with staff to make sure that we capture the spirit and accuracy of the statements made tonight as well. That would also be helpful. If you are all comfortable with that.
Volunteer to do that?
Sure, I'd be happy to volunteer to do that.
Sorry to prevail on you more.
No.
Thank you.
So we will be voting on attachments. It says 8, attachment 8, resolution of the City Council of the City of Belvedere granting appeal of Planning Commission's determination regarding California Environmental Quality Act exemption. Noting the comments by Councilmember Jim Lynch this evening, subject to further review and approval with him subsequently.
And also including comments and revisions to Exhibit A to that is what,
Yes.
oh, okay.
Can we have a motion, please?
So moved.
Second.
All in favor?
Aye.
All opposed?
I don't know which one.
Thank you. Thank you very much. Thank you, everybody, for attending. Move to item 7, which is the open forum and an opportunity for any citizen to briefly address the city council on any matter that does not appear on this agenda. I'll pause for a moment, let the people get up and leave. Is there anybody in the audience who would like to address the city council on the open forum? Seeing nobody. Madam Clerk, anybody online?
Mayor Mark, I see none.
Okay, thank you. In that case, I will adjourn tonight's meeting. Thank you very much.